CRP IO, my lord.
Go to court, the other court.
Okay. Technical structure for listing by MSC appeal. So in this case, I have an IA who withdrawn the 50% of the awarded amount. Can it be on Monday also?
Go there
Register.
before Justice Fukun.
Apply.
Top of the list, item 26.
Oh, yeah. What has happened here?
Your Lordship may turn to page 24. It's your Lordship's order dated 22/5/2024. Operating portion, page 24. Para 3, taking into account the said summons, this court continues the stay so granted by order dated 13/12/2023, subject to respondent ONGC depositing 60% of the arbitral award before the learned executing court. They have deposited, your Lordship, but the district court, and in the meantime, the matter was transferred into the senior civil judge.
Wait. Where's my judgment order?
Starts at page 22, my lord.
That the instant order has been passed on the basis of instructions and undertakings so given, failure to adhere to the condition would amount to vacation of the arbitral award. Okay. Now, directing subject to ONGC depositing 60% of the arbitral before the executing court and 40% of the arbitral award be guaranteed by a bank guarantee. Now, what is the problem?
The problem is that none of the executing court has a bank account in their name. So they give the money by demand draft. The demand draft could not be encashed. So that your Lordship will find at page 56, if your Lordship see.
Which page?
56. Third paragraph. In the alternative, we prayed that let them be directed to give the check in our name. That the court said that in view of the High Court's order to direct to deposit it before the executing court, that order could not be given. Be that as it may I submit, your Lordship, if they may be directed to deposit before the registry of this court, then
we are agreeable to that, Lord. Was only subject to the fact, subject to the observation made by Lordship in the earlier order at page 24, my lord. Any withdrawal will be again subject to them furnishing adequate security to the satisfaction of the executing court, my lord. That observation at para 4, my lord.
Okay.
that
Why?
will be
I have already given
Yes,
the.
that-
So no, not required to deliver. You give the check to him, and then they will give an undertaking before the executing court that in the circumstance the EI is allowed, they will return it.
that will give that.
Or, my lord,
Indemnity bond.
security, my lord, because the order says security, my lord. With that,
That's the security we will give, your Lordship, that
They
give
should
a
give
indemnity
security
bond.
to the satisfaction of the
executing,
giving the security and how they will meet that security.
my lord.
So what they will do, you pay that 60% to them and to the court, the demand draft court, and they will submit a particular undertaking that in the circumstance the 34 proceedings is allowed in their favor, in your favor. Then in that regard, they will be liable to refund it, and how they will refund it, and they have securities to that effect to refund it.
That will give.
Giving. I think that would be fair.
My lords, and another issue, my lords, that arose because my lord's order specifically says, my lords, from a executed from a nationalized bank. Now,
Bank,
all
okay.
banking operations of the ONGC, my lords, are with the ICICI Bank, my lords. So I'll also pray that this observation also be modified, my lords. The bank guarantee in question, we executed it through the ICICI Bank.
I have heard Mr. D. Sanapati, the learned counsel appearing on behalf of the applicant, Mr. B. Chaudhary, the learned counsel who appears on behalf of the ONGC. Pusto. The present application has been filed seeking modification of the order dated 22/5/2024, passed in CRP IO number 71/2024. On the ground that the directions so passed by this court as contained in paragraph number 3 of the said order could not be adhered to on account of the fact that the Supreme Court, that is the court of the civil judge,
Senior division,
senior division number
number.
and the senior division at
One.
Sibsagar, does not have a bank account, which also appears to be correct, taking into account the order passed by their learned executing court
7 to 20.
dated 7/2/2025 in money execution bracket arbitration case number 1/2024. Pusto. The paragraph 3 of the order passed by this court on 22/5/2023 and 4 of the order passed by this court on 22/5/2024 in CRP IO number 71/2024 is reproduced hereunder. Pusto. Next, taking into account, Pusto, Mr. B. Chaudhary, the learned counsel who appears on behalf of the ONGC, submits that the ONGC carries out its banking transaction only through ICICI Limited.
Right.
Banking through carries out all its banking transactions through a bank in the name and style of ICICI Limited. He therefore submits that the directions for submission of bank guarantee of the 40% of the arbitral award, nationalized bank be modified with a direction that the said 40% of the arbitral award, that the bank guarantee be of the ICICI Bank Limited. Pusto. Having noted the respective submissions and the difficulties so faced, this court disposes of the instant application with the following observations and directions. Number 1, the 60% of the arbitral award be paid the 60% of the arbitral award the ONGC Limited shall deposit a check in the name of the applicant, a check, demand draft / banker check in the name of the applicant. Here before the learned court of the civil judge. So in senior division, Sibsagar, within 15 days from today.
There'll be 3 weeks.
You already have that check.
No, we do not have that check, madam. There's a demand draft.
The demand draft only you
The
have to make
check will come from Bombay, my lord, for that very reason.
within 30 days from today. First. Next, the court of the civil judge shall permit the applicant herein oblique the decree holder to take the check. The court of the civil judge so and so shall hand over the check to the applicant herein, who is the decree holder. Check no hai, banker draft or oblique the demand draft. So deposited by the ONGC, the court of the so and so shall hand over the banker check oblique demand draft. So deposited by the ONGC in terms with the directions contained in clause 1 herein above to the applicant oblique the decree holder, subject to giving an undertaking to the effect that in the circumstance the proceedings under section 34 of the Arbitration and Conciliation Act 1996, which have been registered as, what is the number? Registered as?
Your Lordship, just means arbitration
Means arbitration case number
8 of 2024.
1/2023.
8.
1.
One was initially executing court, then it was transferred. Now, the
Means
34,
arbitration case number. No.
34 is the 8 of 2024.
I have written something else. Why?
One is money executing.
No, that is 24. I am saying about 23. No. Kindly see page 23.
The means arbitration ought to have been means execution, which has been
I am not concerned with Miss Execution. I am concerned with Miss Arbitration case number. Kindly come to page
No, Your
23.
Lordship, what has happened is earlier before the district judge, it was means arbitration case number 1 of 2023. Subsequently, it has been transferred to the commercial court. Therefore, it's now
Registered as Miss Arbitration case number 1/2023, bracket, subsequently renumbered as Miss Arbitration case number
8 of
8/24. 24. Shall be submit an undertaking to the effect that in the circumstance, if in the circumstance the section 34 application filed by the ONGC that is Miss Arbitration case number 1/2023, bracket there, subsequently renumbered as Miss Arbitration case number 8/2024, is allowed, comma, the applicant herein shall return the said amount to the ONGC. Full stop. The said undertaking shall also specify as to how the applicant would be in a position to satisfy its undertaking with its assets. Full stop. Number 3. This court further directs that instead of submission of a bank guarantee of a nationalized bank in favor of the learned district judge Sibsagar, the ONGC shall submit a bank guarantee of the 40% of the arbitral award issued by the ICICI Bank Limited in favor of the Court of the Civil Judge Senior Division, Sibsagar. Pusto. 5, 4. Till Pusto. Adi ki tarikh?
13th of June.
13.
This court grants 30 days time to the ONGC to fulfill the above conditions, above stipulations. The award so passed shall remain stayed till 13th of July, 14th of July, 2025. Full stop. Upon deposit of the said, upon compliance to the above stipulations, the learned court of the civil judge, Senior Division, Sibsagar, shall extend the stay of the arbitral award.
Review of it.
For motion, series item 1 to 13.
May it please your lordship.
Tell me.
We have, yes, my lord, we have applied for certified copy,
Hmm.
but my lord, that copy has not been made available on very next day. On 31st May, we applied, my lord. The lordship's order is of 30th May, my lord. We need some more time to produce the certified copy of the order, the entire proceeding, my lord. If your lordship kindly see your lordship's order of 30th May,
Mr. Roy Chaudhary, you are
paragraph 4, my
My lord, I'm appearing for CRP number 37, 38, 39, 41. 37, 38, 39, 41. 36, 37, 38, 39, 41.
now in all these cases, did they decline to adduce evidence?
My lord, what I have received from the written statement, my lord, there is nothing as such statement.
No, in the
Well,
orders,
it
because
records,
here
my
I
lord,
have categorically
That,
referred to.
that order I have seen, my lord, last order, where your lordship says that in one case they have said that.
No, because I have the records of that.
One case, and where they have said they will not adduce evidence. As regards other cases, my lord, we have also have to get those certified copies of those trial court records, my lord. We have got the written objections, but not those. We have got the written objections filed by them in before the trial court.
It is part of our CRP also. Those written objections.
That is the only Mr. Kumar. The problem which is happening is only in one case you have enclosed everything.
Yes, my lord.
Other cases they have not, you
Your
have not
lordship is
enclosed the
right.
other pleading.
No problem.
It seems to be.
Because yes, my lord, batch matters, sometimes it happens, my lord.
No, you cannot, because each are individual cases. It's a different.
So kindly give me,
I may dispose of with one judgment, it's a different thing. But
Yes, ma'am.
for this court, all these things.
Yes, ma'am.
brought in. They brought
Yes,
in
ma'am.
all these things because that is That day,
Yes, my lord, because entirely,
Mr. Kumar, that day after looking into that document, I feel you have a case for an issuance of notice for
yes, my lord.
that. But the question is,
Great one, my lord.
it's been accepted not without protest, that fully satisfied. Because normally the provisions of section 32 would not come. 32 of the Land Acquisition Act would not come. Because the question of protest or no protest
Yes, my lord.
doesn't arise. But if there is a question of
Correct, my lord.
full and final satisfaction with the document which your colleague, the junior, has shown,
Yes, my lord.
then in that
Yes, ma'am.
case, I think ends of justice demands that it should have
My
been.
lord, sir. Yeah.
If that should have been, then obviously
Yes,
it was
ma'am. Yes, my lord.
a fault of the lawyer. So that is the issue.
Yes, my
But
lord. Yes, my lord.
which why I am not
That is
issuing,
yes, my lord.
the moment I issue notice in this matter, means the matter will be
Yes, my
allowed.
lord.
You get the
My
point?
lord, your lordship will examine and
No, there is no
yes, my lordship,
examination.
I quite see what is falling from your
If I
lordship.
issue notice,
And
then I'll have to the question. I will have to remand it back, allowing you to give addition.
or your lordship can balance the equity also.
Hmm?
Your lordship can balance the equity also after issuance of notice, my lord, after examining the matter.
How?
Uh,
Because if it is a full and
Because in
final,
certain cases, because yes, my lord, that is that I can see
because
that the
your
difficulty is that
that document is, the moment I allow the notice means I'm condoning the delay of 2 years in
yes,
filing
my
the
lordship.
proceedings. That is why I'm
In
not
some of the
issuing
matters, my
this.
lord, in some of the
And
matters, lordship. Yes, lordship can impose some
Mr.
cost or something,
No,
and then it will compensate.
Mr. Kumar, kindly see, on all these matters are judgments of 2023. You have approached this court in 2025. In a matter
Yeah, because my
pertaining
lord,
to,
there was
when you don't have a remedy, then it's a more importance that you have to file it with more urgency. One fine morning you just wake up
yes,
and
my
say
lord,
that,
that I
okay,
can
let us
say.
file out the. This is the issue which is the only
No, no,
problem
no.
of this court.
No, what has what has happened, my lord? I took instruction. What has happened that all these matters, the respondents also did not file execution. They started filing execution, then the headquarter came to know, and they started approaching this honorable court by way of revision. There is some gap between on our part, in communication gap at the council level, at the regional office level. There was some
But Mr.
issues.
Kumar,
That is why some delay has taken place, my
but
lord. It was a kind of
but Mr. Kumar, this is what you are saying. But the records does not speak that, no? There is not a single
we will file better
explanation to
affidavit,
that
my lord.
effect.
We'll file better affidavit.
You file
Yes,
better
yes, your
affidavits,
lordship. I'll file better affidavit. I'll file
bringing
better
on
affidavit.
record all the documents
Yes,
and also the certified
yes,
copy.
ma'am.
I think that is a better
Yes, ma'am.
option. And
I'm
you
grateful,
may
my lord.
take that
We
issue
will do that. We will do that.
pertaining to that the without instruction the lawyer must have stated. Forget about the issues. Issues will be there.
Yes, my lord.
Or only way
I got.
the question of issues
Yes,
does
my
not.
lord.
What you need to therefore say out here is that your lawyer concerned without instructions say that there is no evidence. We are not going to adduce evidence. This is the only way out.
Yes, my lord. Yes,
Not
my
the
lord.
question of
I quite
issues.
see what is falling from the lord. We will do that. Yes, my lord. I
Come
understand.
up and file better affidavits
We'll do that. We'll
and
do that.
explaining the delay
Yes,
how.
I'll do that.
Because if
I
you
will do
don't,
that.
without that handle, I cannot do anything.
Yes, ma'am.
Because if it is
I
taken,
will do that, my lord.
if
I
a
will
person
certainly
has
do that.
just
I'm
signed it,
grateful, my
it's a
lord.
different thing. But if you have taken that thing, then if you take that issue out there, that they have accepted it without, not only without protest, but as full and final satisfaction. Then I remember that judgment of the Supreme Court in
Yes, my lord.
ONGC versus PK Ramaya, that 94. 94 judgment.
Yes, my lord, the earlier judgment.
Yes,
Yes,
which
the
is
earlier
a
judgment,
full and final satisfaction
which has been referred.
means you cannot open it.
Yes, my lord.
That
Yes,
transaction
my lord.
cannot be
In
opened.
arbitration matters,
Yes, that is
yes,
the
yes,
arbitration
my lord.
matter.
Yes,
Yeah.
my lord. I will
So
place better affidavit.
So I
Yes,
think
my lord.
you do that.
I will
Because I
place
thought
the,
about it. This is the only
yes,
way,
my lord.
not this issue. Don't come up with this issue business.
We'll do. Yes, my lord, we'll do that, we'll do that.
Mr. A. Kumar, the learned senior counsel, as well as Mr. R. Sharma, the learned senior counsel, appears who are assisted by Mr. N. Khera, the learned counsel, appearing on behalf of the petitioners in the instant batch of writ petitions. Mr. P.K. Roy Chaudhary appears on behalf of the claimants in some of the revision petitions, being CRP number
36, 37, 38, 39, 41.
number kita did. Pusto. Mr. A. Kumar, the learned senior counsels appearing on behalf of the petitioners submitted that pursuant to the order dated 35/2025, the petitioners have filed applications seeking the order sheet of the copies, order sheet of the proceedings. However, the same have not been furnished to the petitioners. Pusto. This court have also taken note of that except in one or two matters in the present batch, the pleadings as well as the other documents pleadings are not the pleadings of the before the courts, before the learned court below have not been filed. First, Mr. A. Kumar, the learned senior counsels appearing on behalf of the petitioner submits that the necessary things will be brought on record by filing additional affidavits in the respective petitions, along with the certified copies of the order sheet. First, the learned senior counsels also submitted that there would be a requirement of filing further details as regards why there has been a delay in approaching this court. So, considering the above, leaves this matter again on 28th of July. 28th of July.
Yes, my lord, it's my lord.
My lord,
28th of July
Yes, my lord.
2025 for further consideration. This is the way out. I've given you the line. Now, if you cannot,
Yes, my lord.
then also do
We
it.
lots, yes,
Because
I'm
This
grateful.
is the only way out.
I will do that, my lord. For
Because
one
Mr.
more
Kumar-
submission, one more
Mr.
submission,
Kumar,
your lordship
my-
has given me liberty to file additional affidavit.
Yes, that by bringing on record, you see, in all cases, you have to file additional affidavit. But in the cases where pleadings are already
Yes,
there,
my lord. Yes, my lord.
there the lower court pleadings are there, then you don't need to enclose there, but you have to explain the delay.
Yes, my lord. Delay and plus, my lord, the statement of my counsel without
Yeah,
instructions. To that extent, also liberty may be given because
that would be required.
Mm.
So this is the only way out.
that would be
And
required,
then
my
it's
lord.
a case of
Yes,
remand.
I am grateful, my lord.
Because Mr. Kumar, my thing is,
Yes,
if I
Yes,
issue a
ma'am.
notice in a matter, it is deemed to allowed unless for exceptional reasons it is not.
yes, ma'am.
So you may otherwise think that other courts are
Yes, yes, I am
strong
grateful, my
enough
lord.
to issue
Grateful.
notice, but mine is different.
Obliged.
No, my
highly
lord,
obliged, my lord.
this
Highly
is
obliged, my lord.
better way in the sense that the matter is resolved once and for all. Grateful,
Yeah.
my lord. Grateful, my lord.
Grateful.
Item 14,
Obliged, my lord.
Huh? Who is your senior? Now let us see what is your case. You argue, Mr. Mahon. You have argued good cases before me. So what is this case about? Section 5 and 14.
Yeah, we have saliency in order passed in the
against the Supreme Court, against the petitioner, there was decreed. Ex parte passed by the so and so and had filed a petition on the order after the judgment and decree and the said petition was dismissed. Against the order of dismissal of the petitioner, prepare the revision. And during the course of the hearing, the same was withdrawn by the petitioner with liberty to approach this court by filing a petition. And after the withdrawal, the petitioner approached the MP's counsel who instructed to obtain a certified copy of demand. The petitioner was of the impression that the impugned judgment order is not appealable, for which he had prepared an What have you filed here?
Here the impugned order page 216, your lordship.
Mr. Counsel, you have to file a second appeal.
Second, lordship,
You have to file a second appeal.
no, lordship, so far the impugned order passed in the limitation petition, your lordship. Because of the order passed in the limitation petition, this
Mr.
Title
Counsel,
like
let me tell you, make it very simple. You file an order 21/97 application. That order 21/97 application was dismissed. Okay? So you file a revision before this court. Now, in terms with order 21, rule 103, when an order is being passed, it is a decree. And being a decree, an appeal lies under 96. Okay? So you withdrew these proceedings and thereupon you went before the first appellate court and filed an application under section 5, read with section 14, 1, regarding condonation of delay and the appeal, isn't it? Now your condonation application has been dismissed. Meaning thereby, what you are required to do is file a second appeal.
so far the, my understanding, your lordship.
Don't go by the understanding, you file a second appeal. Then in the second appeal, I'll frame a question of law as to whether the petitioner was entitled to the benefit of section 5 and 14 in view of the fact that he has taken in remand. And if I allow that hold it as a substantial question of law, then your appeal revives. And then I will do it. This is the way out. Because this is not otherwise going to help you. I can very well notice issue, but what at the end of the day, what is going to happen is this petition is going to get dismissed.
With that liberty.
Because there are many judgments which have been passed. Whereby, and earlier, Mr. Goswami, am I right? Obviously, or you may say so. But there is a judgment. Earlier, there was a full bench. When an application under section 5 in an appeal is dismissed, it is a confirmation of the judgment passed by the trial court and decree. And therefore, a second appeal has to be filed, isn't it, the law? 21/2001, 8 SSC. That's the law. Earlier, there used to be a judgment. I appeared against Mr. Bhatti in one matter. He was referring to the judgment, which was the earlier holding the field of a full bench of the Calcutta High Court, AIR 1983. Mr. L. Mohan, the learned counsel appearing on behalf of the petitioner, submits that taking into account that by the impugned order dated 2/3/2020, passed in Miss Appeal number, Miss J case number 108/2019, the appeal was, the application for condonation of delay was dismissed rejected, and consequently the appeal was dismissed, comma, the petitioner ought to have filed an appeal under section 100 of the Code of Civil Procedure. He therefore submits that that under a mistaken impression, the instant proceedings have been preferred under Article 227 of the Constitution, read with section 115 of the Code. He therefore submits that the instant application be allowed to be withdrawn with liberty to the appellant, to the petitioner, to file a appeal under section 100 of the Code. Full stop. The learned counsel further submitted that the period from 2025 till date be excluded while computing the period of limitation for preferring the present appeal, for preparing the appeal. You have a bigger problem. 2020 order you are challenging now. Anyways, chalo. Taking into account the above, the instant proceeding stands closed on withdrawal. Full stop. This court further observes that the period during which the present proceedings was pending, that is from 2025 till date, be excluded while computing the period of limitation for filing an appeal.
15,
And the lordship,
Yes, where is Mr. Mahmood?
lordship, as per the last order 6625 lordship, we have filed additional affidavit lordship, that may be not on record lordship. So kindly fix the matter on Monday, lordship, with the very.
Monday. Monday is too early. I've given you 6 till date. You have failed. So why Monday? Better have it after vacation.
Lordship, last, next week, any date lordship.
At the request of the learned counsel for the petition, matters stands adjourned to be listed again on 26/2025. So that the directions passed by the order dated 6/6/2025 be complied with.
Deeply.
supplementary item 27,
Yes, Mr. BK Sen, where is he? None has appeared on behalf of the petitioner on call. Let's list this matter. The week commencing from 23rd of June 2025.
for admission item 16,
So did you file the affidavit? Yes, Mr. Dutta, what has happened?
Lord, cold and cough. I don't want to spread it to others.
Why as well as the appellate court? If you don't file an appeal, then
Lordship, let me brief. Only Lordship, after discussion,
understood, but the moment you are putting as well as appellate court, means tomorrow if you know, don't file an appeal, then
ultimately he will get them. Don't file also, he will get there.
but you say it as well as.
Lordship, I may make Lordship by hand also, I can strike it out.
Then tomorrow some other council will come and say that who has instructed him to change my undertaking? Misuse. Now in the age of AI, anybody may sue. Didn't you see the undertaking given in that judgment? I mean, very clear. Why you
The
putting
lordship
that thing?
judgment, my lord, it has been cleared very nicely.
Why you putting that as well as the appellate court? Tomorrow if you don't file an appeal,
Ultimately, same thing will happen also.
eh?
Ultimately, same thing will happen. If you don't file an appeal also, then also he will get.
Then where's the decree from the appellate court?
What's it?
As well as, the word as well as has a lot of meaning.
Understand also.
File it properly. What is the word used out there in that undertaking which is given in the judgment? Can you see that?
Lordship. That as per aforesaid order dated demand, undertake that I shall on my behalf and on behalf of the appellant defendant number 2, demolish any construction made during pendency of the suit and handed over position of the plaintiff in the circumstances the plaintiff succeed in the proceeding initiated. I also undertake that I and the company shall not create any third party right over the suit land during pendency of the suit.
Initiated. So initiated means the decree is not final. It will continue till it is finally resolved. That's a different thing. So therefore, if any decree is passed against us by the Honorable Tribunal Court, it is not required, na?
Lordship,
In the circumstance, the plaintiff succeeds in the proceedings initiated.
Lordship, I will take the instruction today itself. That I will delete at the instruction of my client.
How? You are giving an instruction. Again, the problem is, it is on an instruction. In the first item, that was the case. The counsel said, I don't want to give evidence. And this has led to Power Grid filing petitions after petitions and after petitions. We'll have it next week. You file it properly. affidavit. Succeeds in the proceedings, instead of the proceedings, succeeds in the proceedings initiated, being title suit number so and so. That's all. Yeah, succeeds in the proceeding being title suit number so and so. That's all. What do you need to add? And we also undertake that we shall not create any third party rights over the suit land, as well as the construction. Not the suit land, as well as the construction, no? Because here it is on the construction which is the question. There is already an injunction. I am only allowing you to construct. So you shall not create any error on the construction. Suit land as well as the construction made during the pendency of the instant suit. Mr. Counsel, did you write it? What I said? In this type of matters, first was Mr. Ali's case. He took 3 times to come up with a proper undertaking. But Mr. Sahu was another case where he on the second date. So here we have gone to the second date, the next will be the third.
Your lordship is having a different sort of expertise in the matter.
What?
Expertise in all the matters, my lord, I will say. So that's a clear conception. my lord.
Because you see, this is No, I have always I thought about one thing. Stopping a construction has a lot of implications in a suit.
Yes.
He may have the money today, not have the money later. He is in possession on the basis of some title. As of now, he has a title. That title has to be set aside. So under such circumstances, you are stopping him from enjoying the title. And if any amount of construction without any indemnification from the other side, how is it possible that there is a balance of convenience? This is my understanding.
And also,
Though
I have
in
brought the
most of
judgment
the courts, they stay construction.
regarding limitation also, I have brought the judgment, Lordship has pointed out. Lordship. That's all. Regarding.
Oh,
limit-
that one, yes. Okay. This court have duly taken note of that there is this court pursuant to an order passed by this court on 35/2025, the respondents, the petition appellants have filed an affidavit this court have duly taken note of the undertaking so given at paragraph number 6. The same, however, does not appear to be in consonance. No, this court is not satisfied with the said undertaking. Mr. S.K. Goswami submits that a more specific undertaking would be submitted by way of an undertaking, by way of an affidavit. How much time?
Next week. Lordship.
This matter again on 26/2025.
Okay,
And Mr. Goswami also say an affidavit in support of the grounds, no. An undertaking given.
Supplementary item 28.
Make please, Sir Lordship, my lord. My lord, here, my lord, our submission was recorded in the earlier order, 21/4, my lord. That we filed one, my lord, application under order 6 rule 17 for amendment of the plane. Basically, it's an amendment of the schedule, my lord. Instead of pattern number 16, it should be, my lord, 63, and in the, my lord, boundary.
Other side,
This is
not there. No, where is the amendment?
my lord. My lord, my petition is that page.
And what was the stage at which you filed?
Yes, my lord. The stage, my lord, we adduced 6 witnesses and they were cross-examined. And thereafter, my lord, the last date was for defense, my lord, DW. my lord. Page 51, my lord, is the petition. This we came to know only when.
Mr.
the-
Counsel, there is only one problem,
My
which I said on that date also.
My-
Where do you want the amendment?
That's there is a problem with the, my lord, petition, my.
Then how do I help you?
Yes, my lord. And however, my lord, on our submission, our lordship also considered in the earlier order 21/4, my lord, that amendment sought for. Lordship has recorded that, my lord.
Where do I put it? Where do I say where the amendment happened?
And we have elaborated in this petition, my lord, by saying page 48 is the, my lord, evidence of the Lot Mondal. My lord, he at this stage, my lord, identified the land. And therefore, we filed a petition, my lord.
But where do you want the change?
Change in respect of pattern number, my lord,
Mr. Council, I
yes.
understand that very well, but where do you want the change?
my lord, page
Where will the amendment be?
the schedule, my lord.
Only the schedule.
Schedule as well as a pattern number in the plane, my lord, wherever. my lord.
Where? Wherever means where?
Page 52, my lord, this is the prayer. The
Mr. Council, where?
Yes.
Exactly which area?
My lord, in this is a plain teaser page 11, page 26.
Ah,
This is the description of the shoot land, my lord.
ah.
3 bigger land is measurement of land is correct, 3 biggers. And now, my lord, annual pattern number it is written 16.
Hmm.
But it should be 63. That number is correct, 231. And my lord, boundary note, it should be a Gobat instead of land of Nikun Bharali.
So you have to seek amendment in at page 21, paragraph 4,
My lord.
paragraph 6.
Right.
The other description of the suit land in the said deed, that is the area of 3 bighas is 4 boundaries or, but this is remains the same.
That's the problem is there, my lord.
How do you take care of this? Whether this will remain or not?
So since we have come to know during the cross-examination of the lot bundle only, my lord.
Ah,
So therefore, at the stage of filing the suit,
Hmm.
that perhaps will be there. Because our contention in this petition, my lord, page 48.
so if we only mention
Yes.
the amendment is allowed only in the schedule, would
Yes.
it suffice?
Perhaps, my lord. Yes.
Perhaps.
Yes, my lord.
You do it at your risk.
My lord, because, my
So
lord,
annual patta will be 63
yes,
and not will be
Gobat.
Gobat. What is the judgment in that regard?
My lord, yes, my lord. And so far the stage is concerned, my lord, if it is lordship come to the finding that for effective adjudication, if it is required, my lord, stage would not be the matter, my lord. At any stage, lordship has the power for the arbiters.
I don't have the power
For,
to take it.
yes, ma'am. And 3 judgments I have placed, my lord.
Only one judgment.
Yes, latest one is, my lord, Ganesh Prasad versus Rajeshwar Prasad. Guidelines were given, my lord.
What does he say?
Para 33 and 48.
Huh?
Para, no.
Mr. Council,
My lord. And other judgments also, my lord.
first of all, you should know what you are asking.
My lord.
What you are asking? Amendment of what?
Amendment, in fact, in the schedule, my lord.
So what is required? You must have seen my order, na?
My lord, yes, correct.
What does the order say?
The correct schedule,
You have
yes.
not read the order properly.
I have, my lord, order 7, rule 3. My lord, where the subject matter of the suit is immovable property, where subject matter of the suit is immovable property, the plain shall contain a description of the property sufficient to identify it. And in case such property can be identified by boundaries or numbers in the record of settlement or survey, the plain shall specify such boundaries or numbers. And we came to know only when the lot bundle was cross-examined, my lord. And thereafter, lordship order 20, rule 7, this says, my lord, date of a decree, the decree shall bear date the day on which the judgment was pronounced, and when the judge has satisfied himself that the decree has been drawn up in accordance with the judgment, he shall sign the decree.
Then
Well, here in this case, since we have come to know about the correct schedule under the land under my possession, on my lord 25th of April 2024, when the lot mandal was examined, page 48.
Hey, it has been good from the Maheshwar Sona versus Hemant Sona. So Sona, 2021 6 BL. No, you should have got that judgment. With the judgment of Rajesh.
Yes, yes, my lord.
Got it?
Yes.
Ah.
Rajesh mentioned.
Your submission should be directed on that point.
Right.
Yes.
That I have gone through. My.
Which is-
I have given that copy, my lord, 2023. It is of course in the legal SC, my lord. However,
Not Rajesh sir, Rajesh. Not Rajesh sir, not this one. Oh. Judgment is. Heard Mr. B.K. Das, the learned counsel. Madam, you remember there's a judgment, no, Rajesh? Ah, you have shown this judgment earlier twice. Rajesh, on amendment of. Sir. Citation 9.
but is it, my lord, Rajesh Kumar Agarwal, is it that, my lord? Lordship, then, my lord, KK versus KK Modi.
No, no, no.
Okay. The previous claim that there is interest of beneficial trust. Yes, that perhaps the system will. I have also perished. As a sort for declaration of government. Therefore, planned. There is a plan. What is the- Not assist. Down the permission to amend. We do not assist the economic condition. Permission to fund permission to.
Heard Mr. B.K. Das, the learned counsel appearing on behalf of the petitioner. None has appeared on behalf of the respondent on call when the matter is taken up. The present petition has been filed challenging the order dated
The 12/3/2025, page 59, Miller.
challenging the order dated 12/3/2025 passed by the Court of the Civil Judge Junior Division Number 1, Dhemaji, whereby the application filed by the petitioner being petition number 372/2024 under Order 6, Rule 17 of the Code was rejected. The ground of rejection is
Related approach.
that the said amendment was sought for
After framing of issues.
was sought for was at the stage of trial. And that too. And was at the stage of trial. Was at the stage where the trial has begun. And if allowed, would change the nature and character and would change the suit land, thereby changing the subject matter of the suit, which would cause injustice and irreparable loss to the other side. Mr. B.K. Das, the learned counsel appearing on behalf of the petitioner, submitted that the amendment so sought for was necessitated. Yes. What objection you have? I'm allowing his petition.
I have objection
What objection?
because the present petitioner, plaintiff has occupied dark number 243 and pattern number 16. Now they want to change the pattern number 16 to 63. A boundary they want to change. The necessary character will change. They filed up amendment petition after more than 7-8 years. Moreover, the petition for filing amendment, kindly consider. Nothing, they have mentioned nothing.
They only say that it should be patta number 63, not annual patta number 16.
No,
Yes.
no, misguide these are the report. I'm coming to the point.
Where is the
These are the
petition?
evidence.
Huh?
These are the certified copy of evidence. They have report. They're possessing pattern number 16.
Where?
This is the evidence PW1.
No,
And
it's
it's cost
okay.
examination.
Now kindly see his petition, what he is seeking. Allowing to amend the annual patta number 60, the 63 instead of 16.
Yes,
Yes.
yes. Actually, land belonging the present petitioner from whom? That is a vital one.
No, these are section 6 proceedings.
That's why, they claiming the land per annual pattern number 16, that note 234. From where she has got by way of gift.
No, I'm not concerned about gift. Mr. Bora, we are not concerned with gift. We are only concerned in a section 6 proceedings as to whether he was in possession of that land within 6 months and he was dispossessed without due process. That's all.
Now I'm coming to that point.
No, no.
I
The
mean-
question is that here what he is asking for is that there should be an amendment as regards the number, which he came to learn after the Lat Mandal has said.
Nowhere mentioned in the amendment petition.
But this is the.
Nowhere mentioned amendment petition. It is afterthought. In the petition, it is wrongly stated by misguiding the normal code. That's why I'm coming to the point.
No, did the Lat Mandal say so?
Yes,
my lord.
cost exemption, your honor,
Yes.
your lordship kindly pay.
Case 48, my lord.
Yes,
They have enclosed it.
I have enclosed, my lord, page 48.
The
Last check.
land bearing annual patta number
Yes.
number Iman 234 was wrongly mutated in the name of so and so.
Yes.
Then-
Even though she was in possession of annual patta number 63, Dag number 231. This has been clarified by the Lat Mandal, my lord, in its evidence. Case 48, I have, my lord, enclosed that. my lord. So land was identified at the evidence of the Lat Mandal during the cross examination. So therefore, it's a need, my lord, and we.
So
accordingly
what he
have-
wants is annual patta number 16 to be changed to 63. That's all.
how?
How means I am allowing it?
No,
How?
my lord, actually, the petitioner plaintiff claiming and occupying annual pattern number 16 covered by Dag number 234. But she wants to change.
No, there is no 234 in Dag number 16.
Yes, the revenue record says that
Forget about revenue. This is the Lat Mandal's report.
your lordship kindly consider.
The land
Possible.
bearing annual patta number 16 was wrongly mutated in the name of so and so, even though she was in possession of annual patta number 63 of Dag number 231.
Kindly consider cost part
And my
49.
lord,
49.
case 49, second
49.
paragraph that he
Yes.
has clarified that, my lord. Case 49, second paragraph.
Where I am not
Yes,
aware in whose
14.
possession the land was previously or currently.
Yes,
Therefore, I cannot say whether the land bearing annual patta number 16 of 20 is actually the land bearing number annual patta number 63 of Dag number so and so.
and my last, my lord, last two paragraph, my lord.
I'm not
It
aware if
is
the
not mentioned.
converted land, yeah.
And he has clarified here also, my lord. She
Hello.
was in possession of annual patta number 63.
Kindly peruse the
No
petition.
more, no. I'm allowing,
Minor, kindly, if your lordship allow this petition, the nation character will change.
no, it won't.
Now, boundary, they want to change the boundary. Kindly change boundary.
Boundary, it is the
Not on
court's.
boundary, they want to change. There is a Gubat, but she mentioned another.
Yes, if
Then if boundary will change and pattern will change, what is the stamp?
The
As
question
per
is,
desire, he can change.
but Mr. Bora, he
Yes.
has to then also prove
My lord.
that he was in possession of this land.
Moreover, he suppressed this
And
letter.
you have, there are two aspects. He was in possession of this land within 6 months
My lord,
and you have dispossessed without due course.
Right.
So is it the fact that you have dispossessed?
yes, my lord.
now from.
No,
whose
is
land-
it, no,
from
no,
whose
no,
land-
Mr.
I am disposing.
Mr. Bora, is it the fact that you have dispossessed?
No,
Then
definitely.
what is their problem?
My dark pattern number is 16, 63, and dark number 231. I am still possessing.
There is no 63 up to.
Yes, my patta.
Oh, very well, you be there. He's only asking for 16. You want to
16,
go
16. Yes, 16. I am nothing else. If 16, I am nothing to say.
No,
But 63, they want to change the necessary character. It is very.
Mr. Bora,
My lord.
Mr. Bora, the question is very simple.
My lord.
Whether he was in possession of any particular plot of land
Yes,
in a section 6.
yes,
I'm not concerned with the title.
yes.
Whether he was in possession of that land in New York. The question whether it has been wrongly mentioned as 16 or 63, that he wants to correct it, that should be allowed.
Not wrongly mentioned. In the plain, they have correctly mentioned 16, partner number 16. In evidence on affidavit 16, evidence of cross-examination of PW1, partner number 16. Now, after closing of the PW1, after filing DW1, how they want to say, yes, my land is a partner number 60, 63, not 16. How it is possible?
No, I'm only allowing his amendment only in the schedule to be put it by hand. Thereafter, nothing happens.
No.
They- Mr. Bora,
Boundary also.
boundary rules, I'm allowing that.
Then it will be injustice. Injustice.
Very good.
Law will specific.
His
There is no
injustice.
at all due diligence.
Okay. For me,
There is nothing to say.
okay,
But
then
it will
take
be
your seat.
Greatly injustice to the petitioner,
Very well.
opposite party. If
Yeah.
lordship allow,
I'm allowing.
because after more than 10 years,
Mr. Bora, I've heard you. Take your seat. Kile last. Mr. So-and-so, that though in the plain as well as the evidence adduced, the plaintiff have mentioned the patta number to be annual patta number to be
my lord, for your kind consideration, I may be submit.
Page 52.
as 16,
My lord, I may be submit.
no more.
No, actually, it's still converted annual patta to periodic patta. Now, the patta number 63 partly converted into periodic patta in the name of the opposite party.
I'm not concerned. Tomorrow, if he wins the case, you come. I'm looking here. I'm waiting here for with a CRP 150. Don't worry. Take your seat. Was wrongly written as 16, which should have been 63. And this aspect of the matter came into light during the cross-examination of the Latmandal, which was held on 25/4/2024. The learned counsel further submitted that all along, the plaintiff was under the impression that he was in occupation of land in annual patta number 16 of dag number 231. First, the learned counsel further submitted that this is a case filed, the suit has been filed under section 6 of the Specific Relief Act, seeking recovery of possession from the land where the petitioner was in possession and being ousted, being dispossessed without otherwise dispossessed otherwise in accordance with law. Full stop. He further submitted that on the northern boundary of the land, as mentioned in the schedule, ought to have been Gobat, which was, however, incorrectly mentioned as land of Nikun
Nikun Bhorali, page
Nikun
26.
Bhorali, on the basis of the deed of sale as mentioned in paragraph number 6 of the Mr. L.K. Bora, the learned counsel appearing on behalf of the respondent, strongly objected to the submissions so made by the learned counsel appearing on behalf of the petitioner. and submitted. That the case of the petitioner is pleading case, and therefore the petitioner is not entitled to the reliefs as sought for in the instant application. The learned counsel for the respondent further submitted that if this amendment is allowed, that too at the stage where the DW has the examination in chief of DW1 had been submitted, it would cause serious prejudice to the defendants. First, he further submitted that not only in the plaint, even in the evidence as well as in the cross-examination, the plaintiff have been consistently stating that the plaintiff, that the land is covered by annual patta number 16 and not annual patta number 63. I've heard the learned counsels appearing on behalf of the parties and have given my anxious consideration. This court finds it relevant to take note of that a suit so filed by the plaintiff is a suit for recovery of possession in terms with Section 6 of the Specific Relief Act 1963. It is further pertinent to observe that the proceedings under Section 6 of the SR Act is a proceedings which is summary in nature. What is required to be adjudicated therein is as to whether the plaintiff was in possession of the suit land the plaintiff was dispossessed, otherwise in accordance with law. The second aspect which is required is whether the plaintiff had filed a suit within 6 months from the date of the dispossession. First, this court further takes note of the provisions of Order 7, Rule 3, as well as Order 20, Rule 7 of the Code, which categorically mandate that it is not only the duty of the plaintiff to give an accurate description of the plaint, but it is also an incumbent and an obligatory duty upon the court to ensure that the description in the plaint of the immovable property is correct. At this stage, finds relevant to take note of the judgment of the Supreme Court in the case of A. Rajesh versus so-and-so, wherein the Supreme Court held that amendment of the schedule to the plaint cannot be equated with an amendment to the pleadings contained in the plaint. And for the purpose of passing an effective decree, the amendment of the schedule of the plaint ought to be permitted even at any stage of the suit. This court, taking into account the said judgment, is of the opinion that what the petitioner seeks by filing an application under Order 6, Rule 17 of the Code have been allowed by the learned trial court. That is, to the schedule of the plaint, thereby substituting the word 63 instead of the word in substituting the numerical 63 with the numerical 16 against the annual patta, as well as substituting the northern boundary of the scheduled land from land of Nikon Bhorali to Gobat. Accordingly, this code therefore allows the instant application with the following observations and directions. First, number one, the application file being petition number 372/2024, dated 8/11/2024 by the petitioner, stands allowed, and thereby the schedule of the plaint stands amended to the extent that instead of the word 16 appearing now, instead of the numerical 16 in the amended, by amended by substitution of the word numerical 16 with the numerical 63 against the annual patta, and the northern boundary of the suit land be substituted suit land, and the northern boundary of the suit land, which is land of Nikun Bhorali, inverted comma, stands substituted with Gobat. Pusto. Number two, this court further directs the learned trial court to proceed with the adjudication of the suit by directing the Seristadar of the court of the said court to make that correction in the plaint by hand first. This court, number 3, comma, this court grants a further opportunity to the defendant to file an amended, to file a further evidence, file further examination in chief in support of their case. First, number next, comma. It is categorically observed that the amendment so allowed by this court, as well as the observations made herein above, shall not affect the merits of the trial in the suit. Now next, it is seen that by the order dated 21/4/2025, this court had stayed the further proceedings of title suit number 2/2018. The said stay order stands vacated and the parties are duly represented. They are directed to appear before the learned trial court on 7th of July 2025. A order dated, the order dated 12/3/2025 passed in petition number 372/2024, arising out of title suit number 22/2018 stands interfered with.
It will be better, further proceeding, it is a precedent. It will be better for further proceeding, we are happy.
Yes. That is.
For further amendment, it will be the precedent.
Which
For
one?
after, post-style amendment is liberal.
Huh?
Post-style amendment will be
Yes,
liberal.
Supreme
It
Court
will-
said that.
Thankful to you, your lordship, because further proceeding for amendment of style, it will be better.
No, Mr. Bora, you must not be aware of
My lord.
that there are many judgments of the Supreme Court where it differentiates when a schedule is amended from what is there in the contents of the plate. As I referred to the judgment of Rajesh.
My lord.
Rajesh's judgment categorically says that when you are amending the schedule,
Mm.
it is different from amending what is there, the contents. If he was asking at that stage
Mm.
that I should be amended the other aspects of the plate, then in that regard, I would have imposed cost also. Here I'm not imposing cost because it is the duty of the court to do it. This is for the purpose because you have to read the plaint as a whole. And the question is whether he was dispossessed on such and such.
No, I have gone through it, that's why I'm objecting. I have very much, actually, academical discussing. Actually, what is happening, your lordship has decided. One thing is that the evidence lead by the plaintiff, what will the consequence?
He knows.
What will the
I have not
consequence?
allowed him to adduce further
that's
evidence.
why-
Open for appeal, my lord.
That's why I'm.
This is the contention for appeal.
No, I have not allowed him to adduce
Yes.
evidence.
No.
I've only allowed you to give
Yes,
additional.
that's why I'm submitting.
Now, he will have a difficulty there. But amendment is allowed, so he will have to file appropriate application for amendment if you want to give any evidence.
Must be.
Replay of lesson.
I have to do the calculation.
That one.
Based on the minimum wages, that's it.
But Mr. R. Goswami, the senior counsel appearing on behalf of the appellant insurance company. An application appeal filed under section 173 of the Motor Vehicles Act challenging the judgment and award dated 7/3/2025 passed in MAC case number 476/2022, whereby an amount of rupees 21,98,489.44 have been awarded as the just and fair compensation along with interest at the rate of 9% per annum from the date of filing of the same proceedings. Mr. Arusami, the learned counsel submitted that the victim, who was the deceased, was 17 years old when the person, when the accident took place. And under such circumstances, the learned tribunal could not have arrived at the monthly income
It's 13,704.0.
of rupees 13,704.01. Inasmuch as the victim and the deceased would not be construed to be a skilled or a semi-skilled worker, even as per the notification issued by the government of Assam under the Minimum Wages Act. The Learned Council therefore submitted that the compensation so arrived at was not a just and fair compensation within the meaning of section 168 of the Motor Vehicles Act 1988. The instant proceedings was taken up by this court on 11/6/2025, wherein when this court inquired with Mr. R. Goswami as to what would be the admitted amount, what would be the amount the appellant insurance company would admit, taking into account that the victim was the deceased was a 17-year-old boy. The Learned Council today has placed a calculation sheet on the basis of the notification issued by the government of Assam under the Minimum Wages Act 1948, wherein unskilled workmen, an amount of rupees, the rate per month, the monthly rate, monthly income have been, monthly wage have been fixed at rupees 9,483. He therefore submitted that in terms with the calculation, taking 9,483 as the monthly income, the amount on account of the compensation would be rupees 15,36,408 without taking into account the conventional heads.
Yes, sir.
A compensation in terms with the conventional heads. He further submitted that as regards the conventional heads, the amount so awarded, the appellant insurance company does not dispute. Taking into account the said grounds of the calculation sheet so submitted by Mr. R. Goswami is kept on record and marked with the letter X. Taking into account the above, the instant appeal stands admitted. Call for the record, steps be taken upon so and so. Next. Stay on. Here is an application name so and so. This court having this court having taken into account the ground of objection and the detailed order passed in the accompanying appeal, have admitted the appeal. First, it is seen that the appellant insurance company admits to the amount of rupees 16,57,408. Huh?
Actually, I cannot say I have admitted this, I have made a calculation. If it can be put in a different way. also. I made a calculation, of course, I'll. Let's say, I do not have the authorization to admit this amount. If the lordship allows, I'll advise my client to pay. Lordship. I cannot admit on
This
behalf.
court. What I admit to Gusari. It is seen that on the basis of the calculation as an unskilled worker, come on, the claimant would be entitled to rupees 15,36,408 on the head of compensation, and additionally rupees 1,21,000 on conventional heads. First, accordingly, this court stays the impugned judgment and award dated so and so, passed in so and so, subject to the deposit of rupees 16,57,408, along with interest at the rate of 9% per annum.
May I make a submission? If I deposit the interest, it will not leave much scope for negotiation. Lordship. I would like to settle it on.
There is no negotiation, matter is over then. At 9% per annum. Before the tribunal. Before the Motor Accidents Claims Tribunal number 2, Kamrup Metro at Guwahati, within 6 weeks from today. Next. This court further directs the learned court of the so and so, learned tribunal so and so, upon such deposit to apply the same in terms with paragraph numbers 72, 72, 73 and 74 of the said judgment. However, taking into account that the amounts so deposited have been reduced pending appeal to rupees 16,57,408 along with interest at the rate of 9%. First. এটা কাম কৰক, আৰু এটা ground of objection দি দিয়া, Mr. R. Goswami further submitted ground of objection that the interest so awarded is on a higher side, which should have been 6% and not 9%.
My God.
এইটো এটা দিব, এইটো দি দিব, এইটো state to deliver shall deposit along with interest at the rate of 6%
Yes.
per annum. এইটো দিব. And taking into account the amount is rupees 16,57,408 along with interest at the rate of 6%. Pending appeal. So we have two grounds.
Yes, sir.
One is on additional amount and the other is. I dispose.
Item 17 and 18, hearing under order 41 rule 11 CPC.
May it please the lordship. This appellant is the plaintiff, lordship. His case is that lordship, appellant is the plaintiff, lordship.
Huh?
Appellant is the plaintiff, lordship.
Both the case.
Both the case, lordship. There is a
Okay.
counterclaim by defendant number 2, lordship. So two regular second appeals.
What is the
Plaintiff
suit for decree?
right title interest on the basis of adverse position.
Adverse possession
Yes,
against the defendant, number one. Against the defendant, number one, and sale deed bearing registration number so and so is null and void. Partition you want.
as I am only claiming one kata of land in Schedule B, Lordship. Defendant number one is my uncle. He allowed me to take care of the entire land and he has already gifted one kata of land by the unregistered sale deed, Lordship. That is Schedule B. So after that, Lordship, I am occupying the suit land since 1990. Now, in the year 2003, defendant number one sold out the entire land to defendant number two, Lordship. So I am basing my claim of adverse possession on the basis of unregistered gift deed over one kata of land. Therefore, praying that the registered.
Did your
sale-
sale deed be, was your land sold off?
Yes, Lordship. And the entire plot was sold out by defendant number one in favor of his brother, defendant number two. And defendant number one being my uncle, Lordship, he allowed me to take care of the entire plot of land. On the pretext that I am, Lordship, donating this one kata of land in your favor through an unregistered sale deed. Later on, he will execute the registered sale deed on that pretext, Lordship. That unregistered sale deed was executed in the year 1990, and thereafter I was put into possession. And since then, I am occupying the land. In the year 2003, defendant number one sold out the entire land to defendant number two. But defendant number one filed his written statement. He said that I have sold out the land except this Schedule B.
Then
Forgery was committed by defendant number two. He has written the entire plot of land.
in his written statement.
Yes, Lordship, that is annexure 15.
Then
Then Lordship, defendant number two filed a counterclaim. On the basis of that registered sale deed, he asked for right title interest and eviction of the plaintiff, Lordship. Accordingly, suit was dismissed, counterclaim was decreed. Then title appeal preferred, again suit was dismissed, counterclaim was decreed. Thereafter execution took place, Lordship, they already evicted me. There was a condemnation application, Lordship, we fought for 2 years, then condemnation allowed. Thereafter this second appeal. I have only 144, Lordship, restitution. Only I can apply 144, Lordship, if I win this case. Lordship, on the basis of adverse possession, Supreme Court says the plaintiff can file a suit, Lordship, taking the plea of adverse possession.
why was it dismissed?
Dismissed, the trial court held that my unregistered gift deed is valid. Their counterclaimant's prayer was negated by the trial court. It is valid, but as it is an unregistered gift deed, it does not confer any right title interest. That is the finding of both the courts.
Then
But Lordship, the date from when I am occupying the land, it is from since 1990. So
it is not material.
I have perfect.
Where is your question of adverse?
Lordship, I am occupying the land.
Occupation is not adverse. Occupation, you may have it for 100 years, hardly matters. But where is your adverse? When did it become adverse?
Since 1990, I was
How?
allowed to occupy, Lordship.
You, on one hand, you are claiming on the basis of the gift deed.
Lordship, that is
Well,
an unregistered gift deed, Lordship.
Unregistered gift deed, but you are, where is your statement out there that the unregistered gift deed, you have forgotten about the unregistered gift deed. Now you want that I have more better title. Statement you have plain, show me that. Without that, nothing remains. Where?
Lordship, that is paragraph.
Basis of the sale deed in collusion of so and so, so and so. and then equal title, not equal title, and communication of the document.
In para 2, I have stated that as a permissive possessor, he allowed me to possess.
Huh?
In para 2, I have mentioned that Schedule B, last 3 lines, Lordship, one kata of land within the 4 boundaries. Paragraph three, your lordship will find last part of the month of October 1990. Paragraph three, lordship, clear pleadings are there.
Your entire pleading is wrong.
Lordship, in the last part of October 1990, I approached for registration of the gift deed. Then he denied, and then I stated that since
So
then,
your adverse possession will be when, from where?
last part of October 1990, lordship, when
Ah.
he refused to register, then.
And then your adverse possession becomes from 5/10, first part of October.
Last part of the month of October 1990.
That is last part. But your adverse possession starts from 5/10. See the last paragraph, sentence of that paragraph.
First, I have entered into possession. 5/10,
Understood? See the last sentence of the paragraph.
lordship. An open possession of the plain schedule and as on this date since 5/10/1990 has acquired his title.
How?
5/10, I was put into possession by the.
So,
defendant
so
number one.
therefore, how can it be adverse if you, in the last part, you have categorically said, last part you went kindly register it. That means you are acknowledging him. Then, isn't it contradictory?
Not for that partnership, but because it is within the knowledge of the defendant number one that I am occupying the land since 1990.
Yes, so I mean not
And
like
he is
you-
also not
I
willing
mean
to,
not like that you should be a victim. That's a different thing.
but lordship, he also filed written statement saying that I do not want to sell this schedule B plot of land, but defendant number one, defendant number two, lordship, done fraudulently and lordship included the entire plot in the sale deed. That is his clear written statement, lordship.
He has said that, but he has not filed a suit for cancelling that.
No, lordship.
Then
I have filed that suit, lordship.
your suit is prior to that. You don't know that the defendant number two, the one did not want to put schedule B. Because he filed the written statement after you filed the suit. So you didn't know then.
I am saying that the sale deed which was executed by defendant number one in favor of defendant number two is null and void as because.
Understood. You are saying in null and void for the reason that you are in possession of the suit land, that portion of the suit land could not have been sold. That's it. But the question is, the defendant number one had the title.
Yes, worship, I am admitting title as because.
When
without
you are admitting, so more, therefore had the title, so he sold it. He only later on came up and said that the defendant number two had committed a fraud. So that couldn't have been a part of your plaint unless you have amended your plaint.
I have already stated that apart from that land, the entire sale is valid. Only my one katha is not validly executed.
But the statement of the defendant number one in the written statement came later on.
Yes.
You didn't amend the suit.
Amended plaint,
Did you amend the suit? Plaint? No.
that I have to check, lordship, this is
Let us see how the courts dealt it. And what is your substantial question of law?
lordship. Please,
Committed wrong in dismissing the suit of the in presence of settled principle that the plea of adverse possession is titled by adverse by plaintiff is a valid plea under if not whether the iman is actionable in law in presence of clear admission or any written statement about the date of when the plaintiff is in possession and the admission the suit is part and
I have questioned the sale deed, Lordship. So when there is a denial by the defendant number one also about the area of land in the sale deed, the defendant number two exhibited the secondary evidence. Lordship.
Now, your line is this. Kindly see paragraph 5 of the defend number one's written statement. That is your case. Page 16,
Yes, Lordship.
third line. This is your catch. That line is your catch for your entire suit. The defendant also requested him to vacate the land whereupon he had constructed his residential and other structures.
Since then, I am occupying. So it is admitted by the
So
defendant.
therefore he said to vacate,
Lordship.
but you did not. So your hostile is proved by this document. This is the communication. This is what you should be harping on.
That is why defendant so stated my case, Lordship, in his written statement, and more so, he has also stated in paragraph 6 that I want to sell the land except Schedule B, Lordship.
How does the court deal with it?
Trial court judgment, page 83. Issues, page 98, Lordship.
How your uncle.
Yes,
Your
Lordship.
uncle later on supports you.
No, Lordship, both are my uncle, Lordship. He is also my uncle and defendant number one is also my uncle. Actually, I am since childhood, I am helping defendant number one in his house, Lordship.
Where is the trial court judgment? See,
Trial court judgment, page 83 and the issues, page 98. Lordship. Adverse possession issue is 5. Paragraph 100, page 102 is issue number 5. Lordship.
paragraph 19, no? And the trial court have duly considered the evidence.
Trial
You
court
have
said-
not stated when it became adverse.
But Lordship,
When, because you entered on a permissive
Lordship,
possession.
5/10/1990.
When it became adverse,
That is in my plaint, I have specifically pleaded.
no, you have not pleaded when it became adverse. You asked in the last part of October, kindly do the register sale deed, means in the last week of October, you have asked that.
Lordship,
If you have asked in the last week of October, then it couldn't have been adverse from 5/10.
that is true, but Lordship, in the second line, page 8, I have stated that out of the total land measuring 1 bigha, 1 less as mentioned in the schedule A of the plain, which the defendant number 1 refused to do so. Then in spite of that, the plaintiff enjoying the occupation.
That is different, but did the plaintiff come on a particular date? The defendant come on a particular date asking you to vacate, you did not vacate. Where are those statements? Then only it will be adverse. There have to be specific pleadings. And this is the finding of fact arrived at by both the courts.
Trial court says that Lordship, my possession since 1990 is they
Possession,
admitted. Whether it is
question of
hostile
being
or
in
not.
possession from in time immemorial is nothing to do. But show me anything there where let's see the appellate court, how does it deal with that?
In page 106, it says that PW1 has not stated as to when he denied the title of the defendant number 1.
Neither any pleading is there, nor any, because there's a there are various judgments on this point also. You have to specify the date when it become hostile. You have to specify the
Lordship, when there is a document of unregistered gift deed, since that date also, though I
yes,
think
very
that,
well. Unregistered realty means you are claiming the title through them.
Lordship, but defendant number 1 specifically admitted that later I not willing to execute the gift deed. But that means.
Does it
Lordship-
become adverse?
Lordship,
No. It is your
Then-
burden.
Then he asked for vacating the land, Lordship.
Kindly come to page 139.
Para 39 also, I am saying that though defendant number 2 came, Lordship, he did not get any possession from me.
It is the main problem now. The evidence on record, unless you show me perversity, this, I can't help you with this, the findings of fact. PW1 also not stated as to when he denied the title of the defendant number 1 or when the title of the became hostile. Certainly PW in his evidence stated that in the last part of October, he requested defendant to execute the registered gift deed in respect of one kata of land as mentioned in Schedule B, which the defendant will refuse. As such, he is claiming that his possession has become demand for uninterrupted. From the evidence of it is still clear that he is not disputing the title of the defendant over the suit land and is claiming adverse over the year that described in demand, and if so, the fact of denying the and execute the registered so and so in favor of the defendant, plaintiff by the defendant number one, not amounts to possession of the Iman over Iman and later and turn out to be adverse.
Para 42 said that I have not denied the execution of the sale deed. I have done nothing to.
No, these are immaterial questions. These are nothing to do much. Only question is, now the other appeal is for what?
Against the counterclaim, Lordship, decreeing of the counterclaim.
Why?
My suit was dismissed, Lordship.
Yeah,
Against the,
for your suit being dismissed on the question of adverse possession, you fail. Now, what is the other appeal for?
eviction of me by the defendant number 2
He has a right.
from Schedule 2, Lordship.
The sale deed is held to be good.
Lordship, I am saying that in the year 2003, defendant number 1 has no title. By that time, I have perfected my title by adverse possession. So that sale deed is invalid in respect to Schedule B, Lordship. By that period, Lordship, in the year 2003, defendant number 1 lost his title over Schedule B. I have perfected my title by adverse possession. So if
No. So therefore, if your first adverse possession case fails,
then
the remaining appeal becomes useless.
that is true. But if my suit is decreed, then
Then only the second question will come.
yes. For that only to appeal. If your lordship allows some time, I can obtain the certified copy of the evidence of PW.
You have not looked.
No, certified copy I have not obtained.
Without looking into it, why you are, because you have only way out is, as could be seen from the evidence on record and from the findings of, these are concurrent.
Lordship.
Is that the plaintiff never stated anything when it became adverse.
Lordship.
Because your statement made in paragraph number 3 cannot be said to be adverse because of the fact that on 510, in the last part, you have requested the defendant number 1 kindly execute, meaning you are acknowledging him, please execute.
Lordship.
And again, you say that on 510 it became adverse. How?
It ought to be last part of October 1990.
Should have been last part. It couldn't have been last part also. The moment he doesn't do, it doesn't become adverse. It will only become adverse from the date when he comes out to you and you say that I have title over it. On the basis of that, not on the basis of that agreement for the registered deed of sale, but I have a title. But your title will only mature when? After 12 years.
Lordship.
Then only you can have a title at best.
Lordship. If I
But
go
it has
by-
to be adverse from some point. Because once you enter, because you entered as a permissive occupier.
Lordship.
So for becoming a permissive occupier and to have a year, the burden is much more. Unlike any other case, here the burden will be much more because you entered as a permissive. So the possession has to be, entering into the possession has to be illegal. Then only you are entitled to adverse possession. This is
dependent
also
number-
the law.
Defendant number 1 also adduced evidence as DW code, Lordship. I will see the evidence of DW code also, Lordship. Certified copy I do not have, so I will obtain the certificate. Otherwise, I have the evidences.
Hello. Otherwise, this is the case for dismissal.
Lordship, after 4 weeks, your Lordship can dismiss.
Huh?
After 4 weeks, your Lordship can dismiss.
4 weeks.
Going through the evidence, Lordship. After vacation, Lordship, in the meantime, I will obtain the certified copy.
Both these appeals arise out of concurrent finding of fact by the courts of fact that the plaintiff failed to prove his adverse possession. The plaintiff oblique the appellant failed to prove his adverse possession. In view of such finding, this court, under section 100 of the code, would not be in a position to interfere, since any perversity can be shown. Therefore, to find out as to whether there is a substantial question of law that can be formulated in the instant, both the appeals, Ms. So-and-so appearing on behalf of the appellant in both the appeals, seeks for some time to go through the evidence. List this matter again on 21st
Lordship. 21st July. Lordship.
July.
Correct.
Are you on caveat? I don't record your name.
Obliged.
Stay matters, item 22.
Dusty,
My lord, the other side also appeared, my lord. We have taken steps and we have filed that affidavit also.
your file, huh? Received. Now what is your case?
My lord, in short, my lord, the plaintiff filed a suit for damage of the marbles, which the other side dispatched. Among them, the decree was to the extent of 1,92,000 and odd. Now, the opposite party filed an appeal before the appellate forum. And the appellate court, my lord, said that, so for issue number 4 and 5, the fact end of the argument, the first court, my lord, we appreciated about that 4 and 5, but then sufficient time was not given for the parties. Therefore, it was remanded back to the trial court. And the trial court, my lord, we appeared and we have said that to offer fresh evidence on issue number 4 and 5 and declining to give any evidence. Other side, my lord, they did not appear. Later on, they appeared and said we may be allowed to cross-examine the evidence of the witnesses. That was allowed. Against that, we filed an my lord, review petition that was rejected. And this way, my lord, we are before your lawsuit.
Now, which order you are challenging?
Yes, that your lawsuit will find. In plain order, your lordship will find that.
Oh, first let us see that order. I remember.
Yes,
I have asked you to file an additional.
right,
affidavit.
that I have filed. my lord.
What is there? Accordingly, the impugned judgment is set aside and matter is remanded to the learned trial court with a direction to dispose of them after giving opportunity to the parties for adducing further evidence.
Yes.
If required on additional issue, that is
Right.
issue number 4 and 5 as indicated earlier, part of the judgment. Okay, so for 4 and 5.
Right.
Then what happened? Page 36.
Yes, then your lordship can see at page 36.
Knowing that you will not submit any fresh PWs. Heard and allowed for the same plaintiff evidence clause. Fixed for DW's affidavit. Later on, the defendant side one to cross the plaintiff witness. Heard and so. Is appointed. So you are against this order, no?
Yes, yes,
Page 36.
exactly.
The way is the question of cross, taking into account that there is no further evidence adduced. What happened? The other side not there.
Sir, more was there, he was sitting so long.
Crazy. So let me start dictating by the time he comes. Good. If he doesn't come, Mr. Gore.
Yes,
If he doesn't come, None appears. Heard Mr. S. Dotto, the learned counsel, senior counsel, assisted by Mr. S. Dotto, the junior counsel, the learned counsel appearing on behalf of the petitioner. Mr. Bhatti, your name is there. And appears on behalf of the respondent when the matter is taken up. Okay. None appears on behalf of the respondent when the matter is taken up. First, the petitioner herein have invoked the supervisory jurisdiction of this court to challenge the order dated. What is the order dated?
29/7.
29/7.
Yes, ma'am.
Are you sure?
Yes, page 36.
29/7/2000. That I know, but 29/7/2017. Whereby the learned court of the civil judge, Lakhimpur, not Lakhimpur, had fixed, had without adducing of any further evidence by the plaintiff, fixed the suit for cross-examination of the plaintiff witnesses. First, a review thereagainst was filed,
Page 44, ma'am.
which was registered and numbered as Mizze case number 27/2017. And the same was dismissed by an order dated 18/11/2017. First, the learned senior counsel appearing on behalf of the petitioner, drawing the attention of this court to the judgment and order dated 17th of March 2017 in money appeal number, money appeal, na?
Yes, sir.
Money appeal number 1/2016 submitted that by the said order, the learned district judge, Lakhimpur, had remanded the suit back to the learned trial court with a direction to dispose the suit after giving opportunity to the parties for adducing any further evidence if required on the additional issues, that is issue number 4 and 5 as indicated in the said judgment. First, the learned counsel, senior counsel submitted that pursuant to the said order dated 17th of March 2017, the matter upon being remanded back to the learned trial court, the plaintiff categorically submitted that the plaintiff is not adducing any further evidence. First, the learned senior counsel therefore submitted that when the plaintiff did not want to adduce, he was not inclined to adduce any evidence, the question of fixing the suit for cross-examination of the plaintiff witnesses was an error in exercise of the jurisdiction, in as much as the same would amount to recalling a witness in terms with Order 18 Rule 17, which was not the mandate of the order dated 17/3/2017 in money appeal number 1/2016. This court, upon hearing the learned counsel, finds it relevant to take note of the order passed by the learned district judge Lakhimpur in Money Appeal number 1/2016, dated 17/3/2017. The learned court of the district judge Lakhimpur, who was the first appellate court, who was the first appellate court, had, after going through by the order dated 17/3/2017, set aside the judgment and decree passed by the learned trial court, dated 1/6/2016, and remanded the suit back to the learned trial court. Full stop. Paragraph 12 of the said order being relevant is reproduced hereunder, page 58. Full stop. From a perusal of this above quoted order, it is seen that due opportunity was given to both the parties to adduce evidence, any further evidence, if so required, on the additional issue, that is issue number 4 and 5. Full stop. The plaintiff, now, upon the suit being remanded back to the learned trial court, the plaintiff categorically stated before the learned trial court that the plaintiff would not adduce any further evidence. Full stop. Under such circumstances, the question of cross-examination of the plaintiff witnesses by the defendant did not arise. Full stop. It is further seen that the learned trial court, by the order dated 29/7/2017, at first closed the plaintiff's evidence and fixed 17/8/2017 for defendant's witness affidavit, if any. However, later on, the said order were changed, which also, in the opinion of the court, of this court, was not a proper approach. Full stop. This court also is in agreement with the submission made by the learned senior counsel for the petitioner that the power so exercised by the learned trial court by the impugned order dated 29/7/2017 was to the effect, was akin to the power conferred under Order 18 Rule 17 of the Code for recall of the witness, which was not what the learned First Appellate Court had directed. First, consequently, this court therefore is of the opinion that the impugned order dated 29/7/2017 cannot be sustained in law, for which the same is set aside and quashed. Full stop. This court, it is relevant to take note of that by an order dated 16/3/2018, the further proceedings of money suit number 4/2011 was stayed. The said stay stands vacated, and the parties herein who are represented are directed to appear before the learned trial court on 4th of August 2025 for further proceedings of money suit number 4/2011. Well, how much was the amount?
1,92,000 and odd.
Oh, now, money suit number 4/2011. Full stop. Before the learned court of the civil judge Lakhimpur in money suit number 4 appear before the learned court of the civil judge Lakhimpur. Civil judge bracket senior division Lakhimpur in money suit number 4/2011. And that is why, appear on 4th of August. Full stop. It is relevant to take note of that as in the present case today, when the matter is called up, the respondent is not represented, the learned trial court shall before proceeding with the said, the learned trial court, court of the so-and-so, before proceeding with the suit, shall provide due information to the respondent, to the defendant in the suit.
Much obliged.
For pronouncement of judgment, supplementary item 25 and connected item 30.
Accordingly, this court disposes of the present application with the following observations and directions. The formal judgment and order dated 13/11/2014 passed in CRP number 47 of the 2014 and CRP number 97 of the 2014 is recalled. This court allows CRP number 47 of the 2014 filed by the opposite party number 3 to the extent mentioned hereinafter, and dismisses CRP number 97 of the 2014. The consequential effect of allowing CRP 47 of the 2014 is that the petition filed by the opposite party number 3 before the learned trial court, being petition number 3526 of the 2013, is allowed. The deceased plaintiff is accordingly substituted by the opposite party number 3 herein in the suit, as well as in the supplementary proceedings, which includes the injunction application being registered as Ms. case number 27 of the 2012. The learned trial court is directed to accordingly make necessary corrections in the cause title of the title suit number 41 of the 2012, as well as Ms. case number 27 of the 2012. The title suit number 41 of the 2012, as well as all supplementary proceedings, are revived, and the learned trial court is directed to proceed with the disposal of the suit and the supplementary proceedings. It is further observed that if the suit is decreed in favor of the plaintiff, the judgment and decree would come into effect only when the opposite party number 3 obtains and produces the probate of the will before the learned trial court. Until then, the decree so passed in favor of the plaintiff be considered as provisional and not to be given effect to. It is further observed that in the circumstance the suit is dismissed, the decree passed by the suit would be effective forthwith and subject to being interfered with in accordance with law. The parties herein who are also parties before the learned trial court are directed to appear before the learned trial court on the parties herein who are also parties before the learned trial court are directed to appear before the learned trial court on 10/7/2025 for further proceedings of the suit and the supplementary proceedings. There shall be no order as before. Mr. In view of this order,
Yes, ma'am.
we dispose of the FAO, saying that FAO, the proceedings is continued, so you would not like to press. And it stands revived because of this order. FAO
Supplementary list one pertaining to Koima bench for
No, no.
judgment.
FAO to Dio.
Item 30.
Madam, just wait. Mr. D. Mojumdar, the learned senior counsel, heard Mr. D. Mojumdar, the learned senior counsel, assisted by Mr. B. Kaushik.
Sharma for respondent number 3, Lord.
Mr. So-and-so, who appears on behalf on number 3 and appears on the OP number 2. Good stuff. The learned senior counsel submitted that case civil 255T oblique 2024. CRP number 97 oblique 2024. This court had called the judgment and order dated 13/11/2024. Thirteen 11/2024 had recalled the judgment and order dated 13/11/2024.
14,
Uh,
14.
No, 13/11/2014 in CRP number 97/2024 and 47 CRP number 47/2024, comma. The learned trial court now can proceed with the disposal of means the case number 21/2020. He therefore submits that the appellant herein would not like to press the instant appeal without prejudice to their rights, to her rights in title suit number 41/2012, as well as the supplementary proceedings, which include number 27/2012 and meets the case number 21/2020. Taking into account the above, the instant appeal stands closed on withdrawal. Full stop. Comma. The withdrawal of the instant appeal shall not prejudice the appellant in taking the proceedings for suit number case number so and so. Full stop. The learned trial court shall proceed with the disposal of Ms. J case number 21/2020 pending before it in accordance with law. Learned trial court of learned court of the civil judge, senior division at Jorhat, na?
One observation is it? Page 162, last part the trial court said ought to be kept in abeyance. So to that extent, it is,
Yes, I have said I shall proceed with the disposal.
they will say this order has not been touched.
No, there is no abeyance question because I have revived there, na?
Here in this Nietzsche case 21/2020, trial court said that it ought to be kept in abeyance. The original injunction petition, that is Nietzsche case 27/2012.
Understood. I have revived that in that stage.
In view of that,
I've said that in view of that.
Okay.
Supplementary item one pertaining to Kohima bench for judgment.
The order decision dated 1/10/2024 passed by the Gaobura of the Kohima village is set aside and quashed. This court interferes with the order dated 6/5/2011 passed by the learned court of the civil judge Junior Kohima in title suit number 1/2008 and restores the proceedings being title suit number 1/2008 to the file of the learned court of the civil judge senior division at Kohima. As the title suit number 1/2008 is restored by the present judgment and order, the order of the Kohima Village Council dated 16/8/2008 is also restored. However, the order dated 16/8/2004 passed by the Kohima Village Council would not be operational/executable till the disposal of title suit number 1/2008. It is made clear that the order dated 16/8/2024 shall be subject to the outcome of title suit number 1/2008. The parties herein who are parties in title suit number so and so are directed to appear before the learned court of the civil judge senior division Kohima on 24/7/2025 for further proceedings of title suit number 1/2008. The learned court of the civil judge Kohima shall, on the basis of the pleadings, frame issues and thereupon decide the suit in accordance with law. It is observed that the learned court of the civil judge Kohima shall not be influenced by the observations made in the instant judgment when deciding the suit, being title suit number so and so on merits. The registry of the principal seat of this court shall forthwith return the records of the present proceedings to the Kohima bench of this court. The registry of the Kohima bench of this court shall forthwith, upon receipt of the records, return the records of title suit number 1 of the court of the civil judge so and so and ensure that the records are available before the said court on or before 22/7/2025.
Principal seat item 23, stay matter.
Of course. 11/6, my lord. Indian post, my lord, we have taken statement.
Where's the other side?
They have not appeared, my lord. Service not completed. If we are 11/6, there is an office.
Tracy leave, left. Don't know whether your husband is.
No, that is my, that his original address, my lord. Original.
So, effect service by way of justice. Taking into account that the
Legal Service Authority.
Why?
They have conflict, my lord. Possibly they will not pay.
So you are going to serve. Petitioner need not go there. Who has asked the petitioner to go? Petitioner need not go. Yeah, get it served through your clerk. You take the responsibility of agreeing a matter, you have to take that responsibility of serving also. And if you don't, forget about that case, we vacate the interim order.
If possible, my lord, through legal aid, because case come from the legal aid, my lord, from
Is the legal aid?
legal aid.
The legal aid, why transfer is happening?
I'm engaged with the legal aid council.
Let the legal aid go there. Let us,
My lord.
hey, petition can do. Let us dismiss it. Our petition. Let us dismiss it. They will provide legal aid there.
Through the legal aid.
Huh?
Justice.
Well, transfer from where to
There
where?
is a legal service committee is there, my lord.
Pending before the court of the district area to the family court.
My lord.
So there, obviously, there is no requirement. You can engage the council there. Through legally. We dismiss your petition. Oh, no, dismiss the petition.
My lord, only regards of service, my lord. because,
No,
my
no,
lord,
no, we
I'm-
dismiss. No,
I'm praying, my lord, that.
no, no.
stay, my lord, that they
You
will
do
move
one
through the-
thing. You take help of DLSA, do whatever may be you, that is your lookout. I'm not concerned. When you appear as a legal aid counsel also, that is also your responsibility. Legally, it's for transfer matter legally. Legally, there should have been more for appropriate measures. That's, for example, giving her aid in appearing at court. That should be the legal aid. Not for transferring. Transferring has no business for legal aid. Who has endorsed it to you? I think we should highly take it up with these people. This is absolutely wrong. We have not met the petitioner. Have we met the petitioner? Then why can't she appear? And what is the stage of the suit? And then file it. File your WS. No, no, no. Huh? She's the sole lady. What is the problem? She's 20 years old. Then? She doesn't need to go. She can file it here. She can send it from here and go. She need not go. Let us dismiss it. Either affected by the stay or not. I'm not going to extend. Not otherwise you're going to extend. If service has to be meted out. No service, you are not bothered. Yes, Mr. Gaur, you did not appear in that matter. I disposed it off. You want your name to be appearing? Okay. Hey, Kestut Hall DB. SS S. Dr. appear করেছে. So and so appears. That was the case, because it is otherwise, if there's a cross-examination without anything, it would amount to a recalling the witness, which is not the purview which is being given.
Only, only thing for the issue was subsequently framed without pleading. There is no pleading.
No, very good. He's the plaintiff.
My lord.
So if he doesn't want to adduce any evidence matter,
No, but my lord, on the point that whether he has served the notice under section 10 career segment, I have to cross-examine.
why?
Because my lord,
No, no, if you don't, if you have not stated anything,
Oh, no, but my lord, the suit was decreed against me, my lord. Because
understood, it has been remanded back. You give your evidence. There's no stopping you from giving evidence,
But my lord, regarding whether the notice under section 10, how I can give, my lord?
huh?
Whether the notice under section 10 has been served by him or not. That I
Whether he is served or not, if he have not mentioned in it, and if it is a requisite,
my lord.
then obviously if he has not stated, you take your defense.
No, my lord, my lord, I am the supplier, my lord. Now the transport company is defend number 2 and 3, my lord. So, my lord, the notice, on the basis that no notice was served, suit is against, my lord, defend number 2 and 3.
Because he has not given any of the, you may have to file an application for recalling of the witness, which is a different thing. This has nothing to do. So
Yes,
I
my lord.
said, the court, the plaintiff have not adduced any further evidence, the
Well-
question of cross-examination does not arise. It's a different thing if you want to report, it's a different thing.
Item 22, sorry, 24.
Happy, your lordship. This is my learned colleague, Sir Lordship.
What is the matter about?
They have filed a petition for recalling the reissue the summon lordship.
Huh?
They have filed a petition under order 26 rule 10A lordship. The petitioner defendant. The application is allowed lordship, but when the court summon the witnesses is examined, but he is not present at the proper time of the commission lordship.
Wait, what are you challenging? Is the petition filed with defendant side seeking reissuance of summons to the circular. As per the direction of the name of this court has already issued summons to- I've dealt with this matter. I must have issued notice, yes. The case is-
Petition is allowed lordship, because wrongly person is present lordship.
Heard Ms. Estudi, the learned counsel appearing on behalf of the petitioner, and Mr. So-and-so who appears on behalf of the the supervisory jurisdiction of this court has been invoked challenging the order dated 7/1/2025. Passed by the Court of the Civil Judge Union Division Number 3, Sri Bhumi, hereinafter referred to as the learned trial court, whereby the application filed for reissuance of summons upon the person who was present while carrying out the survey was rejected. বুঝতো? তাৰপিছত লেখক, এই 17/2/2004 5 এইকেইটা লগাই দিব 4 and 5 লগাই দিব। Paragraph 6, this court have duly perused the order passed by the learned court, have duly perused the order passed by the learned coordinate bench of this court dated 8/4/2024 in CRPIO 124/2024, as well as the cross-examination of Sri Abhijit Paul and the impugned order dated 7/1/2025. First, taking into account that the said witness Sri Abhijit Paul had categorically stated that he cannot say as to whether he was present while carrying out the survey of commission, and further his signature having not appeared in the report of the survey commission, comma, this court is of the opinion that the learned trial court ought to have allowed the said application filed by the petitioner, being petition number 566/21. Pusto. The rejection there of the said petition, being petition number 566/2021, appears to be an error in exercise of jurisdiction for which the said order dated 7/1/2025 is interfered with. Pusto. This court further disposes of the instant proceedings, thereby directing the learned trial court to issue summons upon the circle officer Sri Bhumi to appear either to appear by in person or send a witness who was present when the survey commission was conducted. Pusto. This court further takes note of that by an order dated 17/2/2025, the further proceedings of title suit number 20/2025 pending before the learned trial court was stayed. The said stay order stands vacated and the parties are directed to appear before the learned trial court on 21st of July 2025 for further proceedings of the.
Supplementary item 31.
And the petitioner, my lord, yes. Order, my lord, by which, my lord, the amendment was not allowed.
What was not allowed?
Amendment sought for was not allowed. Lordship finds the order at 137.
137.
Order dated 4/7/2024.
Oh, there is a problem.
Hello. So now, it's been drafted by somebody somewhere, my lord, I can only, my lord, place before your lordship. But motions are not to be considered. my
Huh?
Things are not to be construed, so technically, man, it is to be liberally construing.
I can, but what is the amendment you are seeking?
Lord, that your lordship finds
28. What is the amendment you are seeking?
paragraph 7, my lord. Paragraph 6 and 7 at page 129, my lord.
Understood. What am I going to put?
The relief of eviction on it.
Now, understood how? Am I going to word it? Who is going to word that?
I'm going to.
How?
Now the.
No, no,
plaintiff
this cannot be,
insert the
you cannot
consequential
word it.
relief of Eviction of the defendant.
No, no, Mr. Counsel, how can you word it? It has to be worded on affidavit. Then, isn't it a part of the plaint?
Please, my lord.
Then, how is this possible without stating what you want to add? That is the reason why I didn't dismiss with him. On that day only, I would have dismissed if you were there.
My lord, in paragraph 6, my lord, it implies, my lord, that is the consequential relief of eviction, my lord, eviction. That is the word that requires to be, my lord, inserted in the plaint. In the prayer portion of the plaint, not in the body of the plaint. Because
Where?
if your lordship see that paragraph 6,
Additional consequential relief of eviction of the defendant where?
that now the plaintiff beg amendment of the plaint and to insert the consequential relief of eviction of the defendant number 2 with her sons and men and material from the suit land with demolition of the unauthorized houses and structure from the suit land along with the recently constructed permanent structures and shop room with clear vacant possession of the suit land to the plaintiffs. Paragraph 6. This is what to be sought to be inserted, madam.
How? How it is to be worded in the plaint?
That is the relief, my lord, consequential relief of.
No, no, one has to say, na, which amendment is allowed. So should I say that now the plaintiff begs to amendment?
No, my lord. It
Then
will start- it will-
who is going to put it like that? Tell me.
It has been drafted in this manner, my lord. and
I
it
can't
has
help
not-
you. This is not how you draft it. One. Secondly, what is the stage of the suit?
Age of the suit is in the process of PWs, my lord.
Huh?
Evidence of the PW.
PWs. When was the PW started?
My lord, that I am not aware, my lord.
You are not aware of it. This is the most important. When the trial started. Here it says the plaintiff present application is pre-planned because of the plaintiff after 12 years have realized that they have not sought any relief of eviction. Then no diligence. Where is the due diligence statement? Let us see.
It's not.
Yeah.
It's not there, my lord.
Heard Mr.
It can,
I can't.
my lord, there are laws to that effect, my lord, which says that, my lord, there has to be liberal, my lord, to that extent, because ultimately.
Whoever has stated it to be liberal, go to the Supreme Court there. The Supreme Court may help you out. I can't help you
That
out.
is not so easy for everyone.
Heard
to go.
Mr. G. Chaudhary, the learned counsel appearing on behalf of the petitioner, none has appeared on behalf of the respondent.
Because in this
The
petition, I have
petitioner
also
hearing
read the
have
case of
assailed the order
Basawara.
dated 4/7/2024 passed in Mizze case number 68/2021, whereby the application filed under order 6 rule 17 read with section 151 for amendment of the plain was rejected. Case in from a perusal of the impugned order dated 4/7/2024 that the learned trial court.
My lord, may I interrupt for one? If the lordship sees the, my lord, prayer, the prayer is, it is therefore prayed that the honorable court be pleased to consider above and be kind enough to allow the plaintiff to amend the plaint by adding the additional consequential relief of eviction of the defendant, so and so, so and so. So that is there. What is to be inserted, that is there, my lord.
Additional instruction as what is there?
To amend the plaint by adding the additional consequential relief. That means along with the
Of
relief. that has
eviction of the
been claimed.
defendant number 2, so and so with demolition of area, so
Yes,
and
my
so,
lord.
so and so.
Right.
That's all.
So it is there.
Okay, I'll put it, this is not the manner in which it should be.
So,
So what I say is that at least what was my lord required to be amended can be called out from the petition. Well, that is not
Why did it, where's your due diligence?
due diligence is not there, my lord. I have stated, my lord, it's not there, and my lord, in that case, my lord, Basavara's case is very much clear, my lord. That is 22, my lord, Basavaras versus Indira and others. We say that even if I say that, my lord, due to inadvertence and all, my lord, I failed, then also that will not be enough for the purpose of considering due diligence. That is there, my lord. But ultimately, my lord, this procedure is the handmaid of justice, my lord.
No.
So if the actual, my lord, what requires to be amended is there and can be called out from the petition, well, leave it to your lordship, my lord. This is my submission, my lord. I can only, my lord, submit, my lord. The life insurance corporation of India lawsuit is aware, my lord, that in my lord paragraph in the grounds, in clause 10, my lord, it is stated that where the amendment changes the nature of the suit or the cause of action so as to set up an entirely new case foreign to the case set up in the plain, the amendment must be disallowed. But wherever the amendment sought is only with respect to the relief in the plain and is predicated on facts which are already pleaded on the plain, ordinarily the amendment is required to be allowed. So that is there, my lord. Now it's up to your lordship. If your lordship, my lord, want, I can pass over the judgment. Last page of clause 10. My lord, now what happens nowadays, my lord, when these new, my lord, BNSS and BNS have come, even though the IPC and CRPC is not there, for us at least, my lord, to understand, my lord, the provisions of the BNS and BNSS is not clear, my lord. We have to refer to that and then again see the perimeter, my lord, sections in this and go to that.
See the index,
Lawyer, my lord, who had drafted it is a, my lord, 70, 75 years old, my lord, perhaps that has escaped his mind, and that is why I say because procedure is a handmaid of justice, if your lordship should kindly consider on that aspect, my lord. Otherwise, my lord, it goes to the root of the entire thing, my lord. For that, my lord, I'd like to rely upon, my lord, the case of Varun Pahwa, my lord. Paragraph 20. My lord. Allowed to avoid, my lord, multiplicity. So in that consideration, my lord can consider.
first of all, tell me, what type of plaint you have enclosed before the court and the written statement? Is this the manner in which you file it? Huh?
They have, my lord, they've done it, do it like that, my lord.
Is this the manner you file a plaint? This underlines and all?
No, my lord, underline has come out because, my lord, this was not like that. It was marked, my lord, during the process of evidence and the copies were sent to us. That is how we.
So you had to type it out
We
and
had-
file. On this ground only I vacate the stay. You can't read anything.
Sometime I'll retype it and my lord can close around. I type it out, my lord, and bring it.
Now, where is your statement
My lord.
that you have been evicted?
I,
No, you have been dispossessed.
no, my lord, that person, the defendants were there on rent, they were tenants. Subsequently, one of the, my lord, family members, he executed a sale deed, my lord, without having any authority because those were joint property. And by that way, he started construction, and when we came to know about that sale, because it was surreptitiously done, then we filed for certified copies of that, my lord, deed by which, my lord, that sale deed as well as that permission for construction and all, and we came to the court in 2009. The deed was executed in 2000. And in 2009, we came to the court, my lord, when we came to know about that. That is how we came to the court, and that is why we said that at that point of time, that sale deed which was executed was without authority on the person who has executed the sale deed, my lord. And so that is to be set aside, interfered with. The mutation entries that were done on the basis of that sale deed, that is to be interfered with, my lord. And all along, my lord, it was under the intention that they will continue as a tenant. But then what happened, my lord, when this order of injunction was passed, my lord, to maintain status quo, thereafter, my lord, they against, without, my lord, obeying that order of status quo, they started constructions, my lord. Then we came to the court, and at that point of time, when we found out that, my lord, that prayer for eviction was not there, we wanted to insert that prayer for eviction.
No, that is not the question, because tomorrow the suit is going to get dismissed. Otherwise. Because your suit is for confirmation of possession.
Symbolic possession.
You are saying that you have confirmation of the
Yes, we have
symbolic possession.
Symbolic possession.
Yes.
is the manner that
So
landlord-
with that, therefore,
When landlords and owners of
therefore,
the land-
isn't what facts you have been stated in your application, is it not required to be incorporated in the plaint?
But basically, my lord, if that order, my lord, the prayer for eviction is there, my lord, whatever is there in the plaint, it will suffice, my lord. Because already if your lordship sees, my lord, a bond was given, my lord, by the defendant saying that, my lord, after passing of that order, that if ultimately the suit is, my lord, decreed, then we are ready to, my lord, demolish the buildings and, my lord, vacate. So that means, my lord, that they knew about this question of eviction, and it is nothing new, my lord. So whatever is treated here now.
So
my lord,
what you wanted, that the defendant should not be evicted as per your suit.
at that point of time, my lord, when the suit was filed,
Although you knew that there is a illegal deed of sale being made by them,
my lord,
they have all along,
they were tenants.
no,
They were
they were
tenants.
tenants, but they were not claiming as tenants.
At that point of time, they did not claim as tenant because when the suit came in the year 2009, the suit came on the basis of that illegal sale deed which was executed in their
In
favor.
2000.
My lord.
So therefore, in spite of knowing it, you did not ask for this eviction.
We said that it was, my lord, due to inadvertence, it escaped our attention, my lord, because the basic pleadings, my lord. as
No,
it was
it was,
there
it could not have been because you are asking for confirmation of symbolic possession.
As a landlord, my lord, because as a landlord and the owner of the land. the
Where is
only
your
the-
declaration?
always us, my lord.
Where is the declaration that he is a tenant?
The body of the pleadings, it is there, my lord.
No, where is that? Page 47.
No, my lord.
Where is it?
At page 41,
That I can't read it properly.
may I read
So
slowly, my lord?
therefore,
Well,
no.
give me some time, my lord, I'll bring a type copy.
No,
my lord.
no, no.
Refresh
I'm
copy.
not extending the interim order.
Consider, my lord.
No, no.
Matter, my lord.
It is seen that the manner in which the plaint is there. I have copy of the relevant portion. What is this relevant portion?
is, my lord, the missed case, my lord. The missed case which was filed for injunction at page 56.
No, no, annexure one, page 20,
Page 20 is the title suit, my lord.
type copy of the claim. But your justification is not there. Better, there's no justification why you did not seek the plea of eviction.
I said, my lord, in my amendment that it escaped my attention due to inadvertence.
Huh?
In my plaint for petition for amendment, I have stated that it escaped my attention due to inadvertence. That is why I was seeking the amendment, my lord. And that was all subsequent developments, my lord. In the, my lord, amendment, my lord, petition, that your lordships, my lord, finds at page 129, paragraph 7, my lord. That due to some inadvertent mistake, the same amendment could not be made earlier.
So now the suit will go back to that stage. Pleadings. So we'll have to impose a cost. 1 lakh. 1 lakh. This is the, I'll allow you with 1 lakh cost.
The poor lawyer, my lord, is fighting for his properties, my lord. in case,
Can't
my
help
lord.
it.
Please, my lord.
I'm not inclined. Forget about cost, not inclined. I'm not inclined to that.
I'm
No, no. Mr. Chaudhary, I've heard you. Take your seat. Heard Mr. G. Chaudhary, the learned counsel,
Change your
appearing
mind,
on
my
behalf
lord.
of the
My lord, spoken of my favor. Change your
This, the present application has been filed under Article 2 to 7 of the Constitution, challenging the order dated 4/7/2024.
My lord, cost be there, my lord.
Whereby
That, my lord.
petition whereby the application filed under Order 6 Rule 17 being read with Section 151 being Mize case number 68/2021. Was rejected. First, it is relevant to take note of that a suit was filed in the year 2009 and the application seeking amendment was filed in the year 2021. First, the learned trial court had duly observed that the suit had reached to the stage of official PWs after completion of the cross-examination of the plaintiff witnesses. And it is at that stage the plaintiff have sought for amendment of the plain. First, the learned trial court held that as there was no due diligence shown on the part of the plaintiff as required under Order 6 Rule 17, the relief which have been sought for in the instant by way of the amendment of the plaint would not be allowed. This court have duly heard Mr. G. Chaudhary, the learned counsel appearing on behalf of the petitioner. Who submitted. That the amendment so sought for ought to have been allowed, taking into account that the plaintiff have sought, did not seek any amendment to the pleadings in the plaint, but only sought for inclusion of a relief in the plaint. He further submitted that the plaint has to be read as a whole. And as such, the learned trial court had committed an error in not allowing the application seeking amendment. This court had duly taken note of the application so filed seeking amendment, which is mentioned with the heading, an application, inverted comma, an application for amendment of plain arising out of subsequent events. Inverted comma close. In the said application, there is not a single whisper. There in the said application, though various aspects have been mentioned about certain constructions being carried out in violation of the status quo order, but there is no mention as to what amendment has been sought for in respect to the pleadings of the plaint. First, be it as it may, in the relief section of the said application, the plaintiff have stated, the petitioner have stated that they only wanted an addition of the relief of eviction of the defendant number 2, Srimati Bachu Devi, with her sons and men and materials from the suit land, with demolition of unauthorized houses and structures from the suit land, along with the recently constructed permanent structures and shop rooms, with clear vacant possession of the suit land to the plaintiff. First, It's good. Further taken note of. Therefore, this court therefore, taking into account the said application, is of the opinion that the amendment which have been sought for is only as regards insertion of a relief in the plaint and nothing more. First, it is relevant to take note of that at paragraph number 7 of the said application, the plaintiff have mentioned, the petitioners have mentioned that on an account of inadvertence, the said relief was not sought for. First. Be it as it may, it is relevant to take note of that one of the plaintiffs is an advocate. And in spite of that, he had not given due importance and he had overlooked the relief for recovery of possession. However, this court cannot be unmindful of the fact that seeking amendment of the pleadings and seeking an inclusion of a relief by way of an amendment are two different aspects of the matter. First, accordingly, this court, therefore, is of the opinion that the learned trial court ought to have allowed the application seeking amendment thereby to insert the relief sought for to the plaintiff. This court also takes note of that in the application so filed seeking amendment, the plaintiffs have also have done so in a very casual manner without inserting actually without mentioning with specifics as to what amendment, what was the relief so sought for, relief which was sought to be inserted, which is otherwise required to have been specifically mentioned in the said application. Be that as it may, on the ground of technicality, this court would not deny the relief to the petition. First, accordingly, this court allows the application, the present application, thereby allowing the Ms. case number 68/2021 This court further, taking into account the prayer in the said application, inserts the following relief as relief D bracket 1 to the plaintiff. Thus, eviction of the defendant number 2, Srimati Bachi Devi with her sons and men and materials from the suit land, with demolition of unauthorized houses and structures from the suit land, along with the recently constructed permanent structures and shop rooms with clear vacant possession of the suit land to the plaintiffs, inverted comma. Pusto. This court next further directs the plaintiff on the basis of the instant order submit the amended plaint before the learned trial court on the next date so fixed hereinafter. This court further takes note of that by way of allowing the application for amendment, no pleadings have been amended and only the relief have been included, there shall be no further opportunity to the plaintiff to adduce any further evidence. Next. This court further, the stay order passed by this court dated 2011-2024 stands vacated, and the petitioner herein, who is the plaintiff, petitioners herein, who is the plaintiffs, are directed to appear before the learned trial court on 27th of June 2025, on which date the amended plaint be filed to the extent stated herein above. Next. Taking into account that only the relief have been inserted, there shall be no further pleadings in the said suit. Before parting with the record, this court duly takes note of that the instant writ petition has been filed in a very unprofessional manner. The fault, obviously, would not be of the petitioners, but of the counsels of the petitioners. This court, therefore, the manner in which the instant writ petition has been filed, instant proceedings have been filed, does not inspire the confidence of professionalism on the part of the counsels for the petitioners. As a matter of deterrent, this court imposes a cost of rupees 25,000 upon the counsel appearing on behalf of the petitioners to be deposited before the registry of this court within 7 days from today. This court further directs that upon deposit of the said amount, the registry shall place the matter, shall disburse the same to the legal services authority.
Senior Counsel, Mr. SP Bhattacharjee. Your Lordship, after the last order was passed, we have made several attempts to contact our client through phone calls, through WhatsApp messages, but there was no response from our client side. And even the soft copy of our last order was also sent by a WhatsApp message.
It has been submitted by so-and-so, the learned counsel appearing on behalf of the petitioner, that there has been no information available with the petitioner, with the counsel, in respect to the petitioner, in respect to no info from the petitioner. And in spite of various attempts, the petitioner have not responded. It is duly taken note of that in the order dated 21/5/2025, there was a submission made by the petitioner, by the counsel for the petitioner, that a matter have been amicably resolved. So, taking into account the above, it therefore seems that the petitioner is not inclined to pursue with the instant proceedings, for which the instant proceeding stands dismissed for non-prosecution. Full stop. The interim order passed. No, full stop.
Obliged, Your Lordship.
20,
ऑर्डर कागज नहीं है, वो ऑर्डर नहीं है, बनवाना ही नहीं।
Service and respondent is not complete. It is required, so I think paper publication limits the only. The address could not be found. It should be required. You're challenging the involvement of the challenge the involvement of vehicles, so response number 6 should be required. And the address could not be found.
Okay, now the question is, what is your grounds?
Not say in this case, the FIR was filed after 27th. The insurance company sent his investigative report that he tried to contact people local and no one could say about the this. So therefore, they tried to obtain the GD entry, sir. And the police did not cooperate, Lord. Despite applications under RTI Act. The learned member lordship was satisfied that the GD entries are required. And lordship, 3 notices were sent by the learned member on the 7/6/22, 11/8/22, and 7, and making it clear that failure to appear and produce the document proper will entail legal consequences. Thereafter, lordship, police did not appear and member lordship abandoned the EL. And
The charge sheet has been given.
yeah, I think lordship may be given that GD entries are also important. Maybe why is the police not cooperating? They first did not give it. GD entries are easily obtainable. I get it in every case.
But you did not challenge the charge sheet.
Lordship, any status to look at that means the charge sheet. It's for the either owner or the claimant to challenge the charge.
No, once the charge sheet is given, Then it is yeah, because they had submitted the FIR charge sheet, Caesar list, MVI report and all these things. PW1, cross of PW1 also you have declined. Huh?
But Lordship, once the tribunal was convened and the police does not come, the allowed to
The
happen.
record
Police does
says
not
in his
enforce the code.
cross-examination, PW2 admitted that he witnessed the occurrence from the distance of so and so. And Iman MPS denied the suggestion that he did not witness how the accident happened. Evidence is corroborated by following documents exhibited by P1 in his evidence, in our evidence. So and so, so and so, so and so. Thus, in the light of the Iman accident of so and so, yeah. So it is there.
Cross-examination was there, Lord.
Of PW2 is there.
One is also.
Let's see what has come out.
Not the fact that my husband was driving a motorcycle at the relevant time of accident and that his motorcycle was slipped over the sand and fell down and he sustained injury.
The opposite party number 1 with regard to the year denies his rash and negligence driving at the time of the accident and also stated that the vehicle was duly registered as so and so. So the accident is not denied. Now the driver,
Involvement of the vehicle.
huh?
Since from the question that claimant was put to, the case of accident, self-caused accident, and some other vehicle has been implanted.
Accident, the driving license given. Now what is your stand?
May I know the evidence of the claimant, OP3 Lord? The
PW1.
investigator was examined.
Whether victim as a result of injuries sustained by him in the alleged road accident and as the accident took place of remand, whether what is the amount? Salary certificate, everything has been given. I did not see the occurrence myself. I have filed the Ezahar. I have not submitted the charge sheet. I have not deposed in rear case. At the time of the accident, my husband was not in the motorcycle, but he was standing in the certain distance from the motorcycle for answering the natural cause. It is not a fact. It is not a fact. The occurrence happened due to the fault of the husband and so, and I do not know and so and so. Then form AR it is given. Last pay certificate of NF Railway is given.
Special inquiry is not calling the police again, maybe matter get remanded for 3 months. Within 3 months, the whole process can be completed.
Additional evidence given of FIR Caesar list Jimma number MBI report. FIR Caesar list charge sheet Caesar list bail bond.
Otherwise complete.
Huh?
Documentation, my only.
And then after that also you did not cross that. No, you crossed initially. When he gave further evidence, you did not cross.
That part, further evidence earlier.
Now
Not the clear,
DW2 says, now DW2, I witnessed the occurrence from the ER. It is not a fact that the two motorcycles are involved. I noticed a bike near the place of occurrence at the side of the road. The offending bike hit the deceased by overtaking my vehicle on the wrong side. I did not notice whether the driver of the offending vehicle was wearing a helmet or not. The offending motorcycle bike was at high speed. I did not inform the police about the accident. Police recorded my statement at hospital. I have not deposed in any other case relating to the accident except this claim. It is not a fact I did not notice. Nothing is there. Today I have appeared after receiving summons. Now this is by Selina, by
Better
Chief, Chief Officer Superintendent in the Engineering Department. So his last pay has been proved. So that is done, already paid. So this is being proved by him. Entire service record is proved. Now let us see what is your evidence. I, Gautam Putware, I am working as an insurance investigator. I have conducted the investigation including the authenticity and extra time acquainted with the facts. Claim under so-and-so in a motorcycle vehicle is that the deponent during investigation had found that the FIR lodged by the claimant so-and-so was delayed by 27 days. And no same-day GD entry could be collected in spite of repeated so-and-so. Again, the postmortem report does not indicate that the deceased were died of alleged RTA. What is alleged RTA? Right?
Not a case of RTA has been converted into a.
The deponent further said that during the spot visit of the accident, no one could inform the alleged accident leading to the accident. That after due investigation and submitted that the vehicle was not involved in the accident, as the so-and-so was not involved in the accident in question, the opposite party being the insurer of so-and-so is not liable. In the authority letter, during the course of, I have visited claimant's house, owners of the vehicle and driver. I have also collected the statement of the owner. All the persons stated the accident is true.
That's what he said, despite Lordship give reasons to believe. Why is the police not cooperating with them? Why are they not giving the, is there something contradictory that we like? Because it's the first reporting point of time. GD entries. They are supposed to be there considered after Lalita Kumari. GD entries have got a special DL also that these are to be considered as the FIRs. So if that is to some contradictory set of it, then it was just two, maybe one examination the police, let them come and produce the GD entries, Lord. It's a big about 53 lakhs, Lordship.
But there is no proof that I filed RTA.
Lordship.
He also says
Yes, Lord.
in his cross that
Yes.
there is no proof that I filed RTA.
But Lordship, that does not mean the police should not come to the court, Lordship. The court says that will entail legal consequences.
Huh?
And despite the notices the police station, the court said that if they do not appear, it will entail legal consequences. Despite that, police doesn't come after receipt of three summons. Then isn't that, appears to me, they are trying to hide something. Maybe they have been contradicting set of facts in the GD entry. Why is the GD entry not
then
lying in
also,
each and every case?
then also, the question is that there is an FIR. You have not challenged the FIR. You have not challenged that there is no FIR. You did not, you only say that 27, after 27 days, the FIR was submitted. That is the only thing which you have stated.
Please, they are supposed to 27
You have not even questioned on the charge sheet. Even you have not a single question on the charge sheet.
fraud, some fraud lawsuit. Then I think that's a tick all boxes. Like one was, why is the GD entry being withheld by the police? They did not give it to me. They did not reply to RT application. And when the court asked them to come 3 times, they did not come. Is there something to be? That's only one. Maybe the matter can be remanded only for one very limited time, just to prove this particular point. Let the police come and produce the GD entries. I'll be satisfied, Lordship, we are paying a genuine claim. Just to corroborate whether they are. The industry has to very truthfully, everyone said it's true. They will naturally say it is true. It's a big claim, Lordship, I think. Just only one age requirement. If the police would have come and produced the GD entry, this would not have been there.
You have prayed that there should be a direction to the concerned police station
Yes, Lord.
to produce the relevant GD entry. Third, OP side. This is your prayer. OP side is given the liberty to take steps on their own.
Taken steps, Lordship.
Huh?
We had taken steps. 3 times the.
How did you take steps?
The tribunal issued the notices, Lord. 7, 6.
Both sides, the OP has filed a petition praying for time is allowed.
And 3 notices, 7, 6.
Where
11,
is
8, and
it that
7,
you have
10,
taken?
22.
No, but Mr. Goswami, where is it from the records that you have taken steps? See,
That's what Lordship.
they're not there.
But that is dates be there, and even that with that sentence, failure to appear and produce the documents will entail legal consequences. So see, if I see that. Let's check this. Actually, not ready for a hearing today. I thought, yeah.
No,
How to-
I would not have also taken it, but he says that I have only 2 more matters. And I don't rise so early. And then what will people think?
As a
This, this judge has gone wrong, something has gone wrong with him. He normally rises at 5:30 and today he's rising at 3:30.
It's always a pleasure to be here. Lord.
So I can finish it off. We can record to the fact. But tell me one thing. So, Mr. Goswami, kindly come to one thing. Kindly come to paragraph 21 of the judgment.
Page 21.
Paragraph 21 of the.
There are 21. There are 21 is about the computation of the.
Yes. Kindly come to that.
Following is the computation of compensation awarded under head of loss of dependence.
So this is how he has determined. So tell me, this is the compensation. So yeah, if that is the only ground, it makes no sense keeping the appeal pending. You see the records, can you see, there is one order where the court said you take steps. What steps you have taken, nobody knows. And the last line of your witness says, insurance company is liable to pay compensation. Yes, what do you say about the interest?
Interest is 9% that is divided
Why? So high?
from the date of filing.
Why?
So it is a prevalent rate that is given, 9% interest that is given by the Honorable Apex Court also.
Understood, but why? Well, normally it is given 6, but why 9?
Yes, okay.
Normally it is given 6, why 9?
Yes, in some cases, it is given 6%, but some cases it is given 9%. As per judgment of this Honorable Supreme Court,
No, Supreme Court has given in some cases.
9% interest.
9, it has been given, but why 9 here?
It is a prevalent rate, Your Honor, in all cases, in some cases, in my cases, so many cases, the Honorable Court, Learned Court has given this 9% interest as well.
Isn't it required for giving reasons? Normally when it is 6 and it has been made 9. There has to be some reason for that.
Lordship, as per case of Muhammad Sabir Hussain versus Regional Manager UP Transport, as per this judgment, the court has given the interest at the rate of 9%, though here it is, interest given is, yeah, in this case also the interest was given at the rate of 9%. So following.
No, no, there is no quarrel. 9% one can give, but why? Why 9%? Isn't it the reason? Because it's on the higher side.
No, Your Honor, it is actually the case that was filed in the year 2000.
That too from the date of filing of the evidence on affidavit of the people.
The date of filing.
During the COVID period also, it has been given.
Yes.
Because the COVID period, it is not their fault,
Yeah, it is, yes.
isn't it?
Yes, referring this case, is interest 9% given. Referring their case, Sabir, the interest is given at the rate of 9%.
No, understood, but the question is during the COVID period,
COVID period, yes.
interest should not have been given at least.
Because
That
of-
period where the court was not functioning.
Yes.
But
Yeah,
then
restricted
it is not the fault of them. Mr. Gusami,
Find a lordship postal report that steps were taken. Postal report said.
no, kindly see the last, just last to last page of the order sheet. Of that order sheet, there is one order that he said that they filed a petition. That they should, that officer of that Kamalpur police station should be called. Have you got that? Then the court said, heard the OP, the OP number 3 may take steps on their own.
Yeah.
And thereafter, there is nothing that you have taken steps. That? No, postal is there, but how do you interfere with these findings? Very difficult. Your evidence should have been, you're investigating for should, first of all, when he had submitted the affidavit, should have brought that I have been out there, I have talked, what questionnaire had happened. Nothing is there, he just saying, I asked him so and so, so and so. Nobody knows about the accident, that's all. Who said to him?
Very humble submission. This kind of inadequacies are there in insurance. Somehow is there. But it's also a fact there are lots of fraudulent activities that are taking place in that area.
Mr. Goswami, I am aware of that.
Public fund
The-
losses, I just want to satisfy myself before.
Understood. I am also aware of that, but the fact that how do I interfere? Give me a good reason.
For one occasion to examine the police officer can be asked to come and produce the document. They are not even required to be examined. Let them produce the document.
Lordship, in addition to that, under section 160 of MB Act, the investigator is at liberty to collect the documents from the OC or concerned police station,
Yes.
and they are duty bound to provide it.
No.
But in
Yes.
their evidence, in their nothing nowhere, that they have approached the police
You
station,
said
they have
you
filed the
said
RTI application, even cross-examination.
Why,
also.
why didn't they reduce the officer in charge
Yes.
of police station?
Yes.
That was the, yes,
The investigating officer, why
But
didn't they reduce him as a witness?
That he had gone there, they are refusing to cooperate, he had sent the RT application, even that was not written. That's why we prayed before the court
No.
to direct the police station to produce the document.
The
That's all,
court did
they
not,
did not even come.
well,
They
no,
went to produce
where
the
is the order of the court that to produce that document? No,
The court, sent a
court did
someone
not
says to
pass
come.
any order to that effect. Court said that you go and take steps on you. So,
Then that after the process step not by me, but by the court, because we had sent us, goes under court seal.
it,
So,
no,
they have to have lordship, they
no,
come
no,
in that
no,
manner.
the court did not. You should have made him a witness or filed an appropriate application to the effect for production of so and so as evidence, the GD entry. Because that order is very dangerous, the last one. I can do only one thing. 9% interest after the COVID period, that's all.
One thing, Lordship, my learned friend has said that it is not a case of RTA. In our exhibit number 97, Clement said it is clearly stated, written, that the official document, public document, the vehicular accident.
Huh?
Vehicular accident, the involvement of vehicle and vehicular accident, death caused due to vehicular accident. That is clearly the exhibit number 97, Clement's witness, PW1. But my learned friend said that, no, that is, it is not a case of RDA.
Because this application notice, stating very clearly why they want the GDN. There's an application before the tribunal, an application under provisions of order 18 room 17A of the for examination of witnesses.
So what is your next course of action therefore?
The petitioner
But
is-
Mr. That is okay. So what should you have done here? You should have filed an order 41 rule 27.
overlooking, discrepancies or shortcomings of the petition. It's not a yet. Then a lot of public money is involved. Just one satisfaction that did the GDs come before the court. Let the GDs be produced and I'll be happy with the GD also corroborates the affair. Because it all starts with that here, why GDs are supposed to be basic document. Why is it not before that? That's why is the GD being suppressed? The police
That's
not
one.
given-
Let us see the postmortem report. Because the postmortem report must have been done on the basis of a GD.
Yeah, GD number is there.
Yes, number.
GD number is there. Yeah? Yes, sir.
That is not before us. Maybe there's a GD. But why?
Gideon.
not?
So merely because the police does not produce,
Yes, without.
can these people be stopped? Mister, if the police does not produce, can you stop them?
But I don't, they are not giving me also. Lord. That's my whole complaint is they are not giving it to me. Like in other cases, they give it to me. In this case, they are
Then
not
why
giving
didn't
it.
they
They are
file
not
The
giving
oral submission or they are not giving you. Is there any document?
What, you,
That is
they-
submission before the court.
no, you did not even file, produce this RTI
Not even a single
application.
document.
Yeah, this is a job. This could have been. This could ought to have been. But that doesn't mean. that-
But if you, but Mr. Goswami, the question is, even if you are very serious on that one, the insurance company also has to be serious.
Detectable, not easily.
No, it is detectable. But no, Mr. Goswami, I understand. I understand that it is clear, it is detectable, but the lawyer also who was present out there before the trial court also knows what is actually going on. There's no quarrel. You are also aware, I am also aware. Having practiced out there, the lawyer very well knows what is actually happening there.
Would have been better. Effort ought to have been.
But the insurance company also has to be more careful while choosing lawyers there. And this is why it is happening.
They have a penal system and rotation by rotation by.
You see that? You can't help these type of cases.
1 or 2 months, the direction to produce the EA.
Huh? But how do you do it? So, if I was exercising 227 also, I will not see. But how do I do it under 173? Tell me.
Done, it's done. Several police records have been called lots in several cases.
Understood. Police record may be called, but how do I do it?
Turned out in one case, Lordship, these records are there in the undergate. It turned out the vehicle was not, the vehicle owner had come before the police. My vehicle is not involved. He was insured. He did not have any
But
reason
here
to
the
come.
written, here the
And
written,
it turned out actually his vehicle was not involved.
here the written statement categorically of both the parties say that yes, there was an accident, but we were not, there was no ration taken. They do not also mention that the other fellow was driving. There's no mention to that effect also. So you have to, and there is no,
Time. But documents start.
let us, no, but let us see.
After some time.
But Mr. Gustami, let us see only one thing, apart from other. Did you, in your written statement, say anything that there was no accident? Let us see what is your stand. You say regarding involvement of the vehicle is so and so in the alleged accident and such, the claimant should produce and prove the police report, FIR, charge sheet, etc. relating to the accident before the honorable court, failing which denies the fact of the alleged accident. Eyewitness will be examined.
May I Lordship pass on these notices to the police?
What is that? See, these are notices issued pursuant to this order of 27/5/2022. where the court did not direct. OP side is given the liberty to take steps on their own. So the court did not direct. And these have been issued by this head assistant without knowing it. How could he issue this? The court never directed this. These which have been issued is being wrongly issued. Only one thing I can do is during the COVID period, the interest can be waived. That if that is the thing, that is the only thing which he is agreeable.
After exhausting all the,
Eh?
I've exhausted all my means lots.
Because I could have kept it pending, but this is going to only go up. Problem arises with the FIR, charge sheet, everything having been given, and you did not question that. Problem arises that you should have put a question to that effect. That why is this? Let us dispose it of them. This is an appeal heard Mr. R. Goswami, the learned counsel appearing on behalf of the petitioner. Appellant, Mr.
Yes,
So-and-so,
yes,
who
sir.
appears on behalf of the
Respondent number 1 to 5.
respondent numbers 1 to 5. First, none appears on behalf of the respondent number 6 and 7. First, this is an appeal filed under section 173 of the Motor Vehicles Act 1988, for short, the Act of 1988, challenging the judgment and decree, judgment and order award dated 8/4/2024, passed by the learned member Motor Accidents Claims Tribunal number 1, Kamrup Metro at Guwahati, whereby the learned tribunal, learned tribunal, awarded an amount of rupees 53,38,941, along with interest at the rate of 9% per annum from the date of filing of the evidence on affidavit of the PWs, that is 26/11/2019 till realization. First, Mr. R. Goswami, the learned counsel appearing on behalf of the appellant, submitted that the present appeal, by way of the present appeal, the appellant insurance company urges the following grounds of objection. Number one, that the findings were arrived at by the learned trial court, learned tribunal, without consideration of the GD entry. Findings were arrived at by the learned tribunal in respect to issue number 1, without perusal of the GD entry, was not in accordance with law, and as such is required to be interfered with. First, elaborating the said submission, the learned counsel submitted that the FIR in the case was filed after 27 days. And as such, the GD entry was a very vital piece of evidence which ought to have been taken into consideration by the learned tribunal. First, the learned counsel further submitted that steps were taken on behalf of the appellant insurance company before the were taken on behalf of the appellant insurance company with upon the officer in charge Kamalpur police station for production of the GD extract pertaining to Kamalpur PS case number 20/2018. But in spite of taking steps on 3 different occasions, the Kamalpur PS, the officer in charge of the Kamalpur PS, did not produce the said GD entry. He therefore submitted that this is a case where there is a very strong likelihood that the alleged accident did not happen. And is a case of a fraudulent claim. Isn't it? Yes. Number 2. The learned counts the second ground of object number 2. Mr. R. Goswami further submitted that though the claim proceedings was filed in the year 2018, or filed on 2/2/2018, and the learned tribunal have also acknowledged that there was no there was nothing, they have duly acknowledged that the appellant insurance company was not involved in the delay of the said proceeding. Had therefore fixed the, have therefore awarded interest from the date of filing of the evidence on affidavit by the PWs, that is 26/11/2019. But taking into account the COVID period, taking into account that during the COVID period, there was the functioning of the courts had stopped, the interest during this period ought to have been waived. These are the two. At the outset, the learned counsel appearing on behalf of the claimants submitted that the respondent numbers 1 to 5, who are the claimants, have no objection in waiving of the interest during the period of the COVID and calculating the interest with effect from 1/3/2022. Taking into account the period of the COVID from 15/3/2020 to 28/2/2022. The learned council therefore submitted. The learned council for the respondents number 1 to 5, however, submitted that the rate of interest should not, ought not to be interfered with. First, in view of the submissions so made by the learned council appearing on behalf of the respondent numbers 1 to 5, the second ground of objection which have been taken by the learned council appearing on behalf of the petitioner appears to have been redressed. First, the question therefore arises as to whether interference to the impugned judgment and award dated so and so is called for on the first ground of objection as noted above. First, in this regard, this court finds it relevant to take note of the brief facts which led to the filing of the present appeal. On 25/12/2017 at around 1:30 p.m., the one Toroni Kontodeka, who was working as
The maintenance, track maintenance.
one Toroni Kontodeka was knocked down by a motorcycle bearing registration number AS01DH3495 while he was proceeding by the left side of Naukasi Road at Boragao to answer the nature's call. The accident, the injuries so suffered by the said Toroni, by late Toroni Kontodeka were grievous in nature, for which the said late Toroni Kontodeka expired, succumbed to his injuries. First, thereupon, the record reveals that on 25/12/2017, information was given to the Kamalpur police station on the basis of which, in respect to the accident, on the basis of which GDE number 511/17 was entered. First, on the basis of the GDE entry number 511/2 dated 25/12/2017, postmortem was carried out of late Toronikanto Deka, wherein it was reported, wherein it was observed that the accident occurred on account of vehicular accident, wherein it was mentioned that the cause of that to be vehicular accident. It is further relevant to take note of that subsequent thereto, on 21/1/2018, the FIR was lodged by the claimant number 1. And on the basis thereof, Komalpur PS case number 20/18 was registered under section 279/304A of the Indian Penal Code. The record further reveals that in the said proceedings, and that pursuant to the investigation, the investigation, charge sheet bearing number 02/2018, dated 30/1/2018 was submitted. Further to that, the record also reveals that prior thereto, on 17/1/2018, the investigating officer had seized the concerned motorcycle as would appear from the seizure list, being number MR NO MR being with the number MRNO 5/18. It is also seen that on 17/1/2018 itself, the MV report was submitted. Subsequent thereto, the applicant, the claimants, instituted the present claim proceedings. On 2/2/2018. The record reveals that notices were issued upon all the three opposite parties. The OP number 1 and 2, who were the driver and the owner respectively of the offending motorcycle bearing registration number AS01BH3495, had filed their respective written statements. It was categorically mentioned that the vehicle in question was duly insured with the appellant insurance company, and the driver concerned had a valid driving license. There was no denial to the alleged accident, But what was denied was that there was no rational negligent driving. On behalf of the appellant insurance company, written statement was filed raising various preliminary issues, raising the usual defenses and putting the petitioner claimants to the strictest proof. On the basis of the pleadings, the learned tribunal framed two issues, which being relevant are reproduced herein under. Paragraph 3 to the judgment or paragraph 3. Taking into account the ground of objection which is this court is presently dealing with, the decision in respect to issue number 1 assumes importance. As well as on the discussion on the evidence so adduced. On behalf of the plaintiff, claimants, there were 3 witnesses who were examined. First, the claimant number 1 submitted her examination on chief by way of an affidavit, wherein the following documents were exhibited. Exhibit 1, accident information report. Exhibit 2, postmortem report. Exhibit 3, salary certificate. Exhibit 4 to 4.2, birth certificates of daughters and son. Exhibit 5, voter ID of the claimant number 1. Exhibit 6, PAN card of Srimati Dayabala Deka, oblique claimant number 5. Claimant number 5, na? Exhibit 7, identity card of late Toroni Kanto Deka. Exhibit 8, PAN card of late Toroni Kanto Deka. Exhibit 9, certified copy of the FIR. The plaintiff, the claimant witness number 1 was cross-examined. But nothing substantial could be culled out, by which the evidence of the claimant witness number 1 was affected. The evidence, but nothing substantial could be culled out. The claimant witness number 2 was the eyewitness. No, Pusto. It is further was the eyewitness. Who had seen the accident. Pusto. The claimant, the opposite parties, number 3, though cross-examined, but nothing substantial could be brought in their favor. The claimant witness number 3 was the chief office superintendent in the engineer department of the NF Railway. Who appeared to prove the salary statement etc. Salary statement, comma, the employment details of late Toroni Kanto Deka. It is further taken note of that pursuant to the evidence adduced by it is further relevant to take note of that the claimant witness number 1 adduced further evidence pursuant to the leave taken from the learned tribunal. And by way of the said evidence, comma, the claimant witness number 2 exhibit 91 to 97, which were the FIR, comma, charge sheet, comma, Caesar list, comma, Jimma number, comma, MBI report, and the postmortem report. Pursuant to submission of the said FIR, said additional affidavit, the record reveals that that the opposite appellant insurance company declined to cross-examine the plaintiff witness, the claimant number one. First. Next. On behalf of the claimant, the appellant insurance company, the insurance investigator had filed an evidence on affidavit wherein it was mentioned that FI was lost after 27 days and there was no same day GD entry which could be collected in spite of RTI applications. However, those RTI applications so submitted were not brought on record by way of any evidence. It was further stated in the examination in chief by way of affidavit that a vehicle, motorcycle bearing number AS01DH3495 was not involved in the accident in question, as he could learn after carrying out due investigation. Be it as it may, the investigation report was not brought on record. It is also relevant to take note of that during his cross-examination, he had categorically stated that he met the claimants, the owner of the vehicle as well as the driver of the vehicle, including, and also went to the police station, and all persons stated that the accident is true. It was categorically also mentioned during his cross-examination that the deceased, Toroni Konto Deka, died due to the accident occurred on 25/12/2017. At this stage, this court further finds it relevant, taking into account the submissions so made by the ground of objection so taken, that a petition was filed by the appellant insurance company before the learned tribunal bearing petition number 2137/22. No, 2138/22. With a prayer to direct the concerned office police station, that is Komalpur Police Station, to produce the relevant GD extract. First, it is relevant to take note of that the learned trial court tribunal did not agree, did not pass any order in the favor of the appellant insurance company, as would be seen from the order dated 27/5/2022. Rather, directed the appellant insurance company, the appellant insurance company was given the liberty to take steps on their own. First. During the course of the hearing, Mr. Argusami placed before this court some of the notices which were issued. By the learned tribunal. But the question arises, how could these notices at all be issued when there was no direction issued by the learned tribunal to the officer in charge of Komalpur police station to produce the relevant GD extract? And more so, when the appellant insurance company was directed to take their steps on their own. Therefore, those notices which were produced, photocopies of those notices which were produced by Mr. R. Goswami, in the opinion of this court, does not have any value. From the materials on record and the evidence so adduced, it is clear that there was an accident which took place on 25/12/2017. And on account of the accident, late Toronikanta Deka expired, sustained grievous injury and succumbed to his injuries and expired. The materials on record, including the admissions, including the written statement filed by the opposite party number 1 and 2, categorically so. No. The evidence on record, and more particularly the evidence of PW2, categorically shows that the appellant, that the accident occurred on account of the rash and negligent driving of the motorcycle. First, this court have duly taken note of the manner in which the learned tribunal have dealt with issue number 1. And taking into account, and after perusing the evidence on record, this court is also of the opinion that the accident occurred on account of the rash and negligent riding of the motorcycle bearing registration number AS01DH3495. Therefore, the first ground of objection which have been taken by the appellant does not cannot be a good ground of objection, good ground to interfere with the impugned judgment and award. Next, taking into account the above, this court have also perused the discussions so made by the learned trial court as regard the issue number 2, and the amount so arrived at of and the compensation so arrived at to the tune of rupees 53,38,941 cannot be said in the opinion of this court is the just and fair compensation in terms with the well-settled principles of law. This court have now coming back to the issue pertaining to the interest comma, it having been agreed to by the claimant not to claim interest with effect from 26/11/2019, but with effect from 1/3/2022. This court, therefore, comma, the interest at the rate of 9%, so awarded by the learned tribunal, shall be effective on the entire amount future perspective. How do he has arrived at future perspective? Following addition of 30% of the established income, the total income of the deceased to be met. So what he did is he joined together everything. He has joined together everything. Hmm. 9% with the year. Be that as it may, it cannot also be this court cannot also be unmindful of the fact that the coordinate benches of the learned coordinate benches of this court have not granted interest on future prospects. Therefore, there would be modification of the award in the following manner. What is the future prospect?
30% of the.
No, that's okay. How do you identify it now? This is 43,000. After deduction of 1/4 is there. After multiplication, 3 lakh.
33,287 is the base figure on which 30% has been applied. So 43 minus, this should be the.
Would be as follows. তাত লেখক first থেকে এইটো আগৰ এইটো change হ'ব. No, this will remain as it is. Otherwise, the computation is okay. Oh, computer, good stop. Accordingly, this 10 modified, good stop. Accordingly, the interest, accordingly, the instant appeal stands disposed of with the following observations and directions. The claimants herein would be entitled to the amount of rupees 53,38,941, which is the just and fair compensation. Number 2, there shall be interest at the rate of 9% per annum with effect from 1/3/2022. So here this should be minus, na? 43,273 minus it with 33,287. And then multiply it by 13. How much? That will be the future prospects.
Salary statement.
Ah.
PW three also deposed, the PF is a deduction, but it is a savings.
No, 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 I'm not on that. You see, 30% is taken as the future prospects. So therefore, his net salary has been arrived at 33,287. Kindly page paragraph 18, isn't it? And along with future prospects, he has now arrived at 43,000, isn't it? So 43,273 minus 33,287 is the future prospect amount, which will be multiplied by
Yeah.
13.
13.
And whatever is arrived at, no, which will be multiplied by 13. No, it cannot be. It has to be multiplied by, it has to be again divided by 1/4. After we have to deduct 1/4. If you,
That has been deducted.
no, understood, that has been deducted. The problem what he has done is he has direct added 30%. So what he did, 33,287 into 30% divided by 100 is what he did. Now what is required is, this is the future prospects, which is the 10,000, which should be whatever may be. Now, once he did this 43,000 into 12 is the monthly, and then 1/4 he took it out.
Yes.
And then multiplied it by 13. Shalom. So therefore, what is the required is, on this 10,000 amount, it has to be multiplied by 12,
Yeah, multiple by 13.
taken out 1/4,
Yes.
and multiplied by 13
again.
would be the amount of future prospects. Isn't it?
Yes.
Am I right? I am not good in mathematics, so therefore I am asking you. This seems to be the only way out. Because we have to have the same calculation.
Simple.
And that would be the amount, there shall be no interest. Out of this amount will only have 9% interest, which I'll put it in the order. And this amount shall not carry any interest. And deposit it within 6 weeks. You kindly make that calculation.
Okay.
And once it is being deposited, it shall be applied in the same manner as has been given in these paragraphs.
All right, course.
Ah, good. Tell me,
My lord,
what is the matter about?
my rejection of my application, filed for amendment.
Huh?
Rejection of my application, filed for amendment of the plain.
Filing WS. Why rejection?
Rejection of plain. Amendment petition. Rejection of the amendment petition for amendment plain.
Rejection of the amended.
Petition.
Ah.
for
Where
amendment of the
is that
plain.
order?
At page 11,
Page?
11, 111.
Oh, that's statutory deposit to whom I had to deposit corruption evidence being produced. Anyways, Mr. Goswami, we got one matter done. Yes, what is this order?
Rejection of my application, my lord, for amendment of the plain.
What type of order is this? What type of order is this? Where did you get this type of order? You cannot have this type of order. How do I know that this is the order? And this order was passed on 2024. Have you got the certified copy? Then how can you file on this basis?
Civil Judge Senior Division. The Court of Civil Judge Senior Division, Assistant Session Judge number 3, Kamrup Metro.
Generally, amendment to the pleading should be allowed if if they are necessary for determining in the instance the amendment sought by the plaintiff is not consistent with their. If the amendment to include the MS so and so, we cannot do it on this basis. This type of order cannot be filed. No, and you have not enclosed it. We vacate that interim order. Interim order is there. No, you have not filed it. We vacate this type of interim. We vacate, no?
My lord, I'm ready to file.
And it is just round the corner. You have not done it. And how did it file? List this matter on 26/2025, the registry shall submit a report as to how the order at Annexure A how the impugned order in the form of Annexure A could have been permitted to be filed. You make that correction.
Yes.
I'm not interim order, I'm not extending it.
In the meantime, if you were to file.
No. This will, nothing is going to happen in 7 days, no? I'm not extending it with this type of petition, no?
But